threatening and abusing people because they are exercising their fundamental right to go to court undermines the rule of law. Anyone who communicates such threats or abuse should be aware that there are legal powers designed to ensure that access to the courts is available to everybody. Secondly, it's right to record that at the direction of the court, the registrar has asked all the parties involved in these proceedings whether they wish to ask any of the justices to stand down. All parties to the appeal have stated that they have no objection to any of us sitting on this appeal. Third, these proceedings involve a large number of parties and a great deal of legal submissions and supporting material, and the proceedings have come to this court very quickly. That this has occurred in an orderly fashion is entirely thanks to a lot of hard work done by and cooperation between the parties, their lawyers and the court staff. The justices would like to thank all those involved. There are an unprecedented number of lawyers and party representatives. We're grateful to them for agreeing seating arrangements, which involve many of them sitting in less convenient places than they may have expected. We've been keen to ensure that members of the public can be here, and given the limited space, this has meant that not all members of the legal teams can be accommodated in the courtroom. All parties have filed written submissions, which we've carefully read. Because of the limited time available for the hearing, we've had to ask some advocates to confine their submissions to their written argument, and others to spend less time developing their oral submissions than they would have wished. We're grateful for their cooperation and understanding. And I remind those advocates who will be addressing us that their oral submissions must not repeat points already raised by other advocates in earlier submissions. Next, many people are watching these proceedings because they are being streamed on our website and broadcast on television. This is a very important aspect of open justice, and we're pleased that so many people are able to read the written arguments online and listen to the oral arguments as they are being developed. Finally, I would like to take this opportunity to remind everyone who's taken an interest in these proceedings that the Supreme Court exists to decide points of law which fall within its jurisdiction. The justices of the court are, of course, aware of the public interest in this case, and we are aware of the strong feelings associated with the many other wider political questions surrounding the United Kingdom's departure from the European Union. However, as will be apparent from the arguments before us, those wider political questions are not the subject of this appeal. This appeal is concerned with legal issues, and as judges, our duty is to consider those issues impartially and to decide the case according to the law. That is what we will do. Mr. Attorney.
My Lady, my Lords, good morning. I appear on behalf of the appellant in this matter, and I know that the court has seen a list of other representation in this case. In the interest of time, I won't, unless the court wishes me to, take you through that.
Very sensible.
I'm grateful. I know the court also has a timetable as to the submissions that will be made, and I know that all counsel will do their best to keep to that. There are, if I may, 2 points I wish to make at the outset on which I believe all parties are agreed, and they follow from what my Lord President has just said. The first is that this is a case of great constitutional significance, in which there is understandable and legitimate interest both inside and outside this courtroom. And second, in light of what followed the divisional court's judgment, it should be said with clarity that this is a case which the claimants brought perfectly properly and which it is now perfectly proper for this court to decide. And that is so because there is a clear question of law before the court, namely whether the government has the legal power to give notice under Article 50 of the Treaty on European Union to begin negotiations for the UK's withdrawal from the EU, or whether further specific legislative authority is required to do so. That, we submit, is a clear question, but it is not a narrow one. it raises issues going to the very heart of our constitutional settlement. The question arises, of course, because the United Kingdom is about to leave the European Union as a result of a course of events which I submit it is worth restating. At the last general election, the government was elected with a manifesto commitment to hold an in-out referendum on the UK's membership of the EU. Parliament provided for that referendum through the European Union Referendum Act of 2015. The referendum was conducted, we say, in the universal expectation, including in Parliament, that the government would implement its result. As the Foreign Secretary told the House of Commons at second reading of the bill, and I quote, "This is a simple but vital piece of legislation. It has one clear purpose: to deliver on our promise to give the British people the final say on our EU membership in an in-out referendum by the end of 2017. My Lords, I don't propose to ask you to turn to that, but if you wish to find it, it's at volume 18 of the bundles, tab 203. A majority of those who voted in the referendum wanted the UK to leave the European Union, and Article 50 provides the specific legal mechanism to begin doing so. Now, my Lords, the Divisional Court treated all of that as legally irrelevant and concluded that the process could not lawfully be begun by the government using prerogative powers, but only by further legislation in Parliament. We say, respectfully, that the Divisional Court was wrong about that. We say the use of the prerogative in these circumstances would not only be lawful, but fully supported by our constitutional settlement, in line with parliamentary sovereignty and in accordance with legitimate public expectations. So in opening this appeal, I make three submissions by way of introduction to our case from this fundamental constitutional perspective. My then friend Mr. Eadie will then develop our case, and the Advocate General for Scotland will deal with the devolution and other issues raised in relation to the Scottish, Northern Irish and Welsh jurisdictions. And my three submissions are these. First, that the Foreign Affairs prerogative is not an ancient relic, but a contemporary necessity. Including the powers to make and withdraw from treaties, it is a fundamental pillar of our Constitution as a sovereign state, and it is essential to the effective conduct of public business. Second, that the prerogative operates as part of a dualist system, including in the EU context. And third, that the prerogative operates wholly in accordance with parliamentary sovereignty. Parliament has a clear understanding of the constitutional function and usefulness of these powers, and where it chooses to limit them, it does so carefully and specifically. So my first submission is on the importance of the Foreign Affairs prerogative. The powers to make and unmake treaties, to conduct diplomacy, or take part in multilateral decision-making do not, we say, reside with the executive as unfinished business or as a result of historical oversight, but because there are good constitutional and practical reasons why they should. The need for the government to maintain control over strategy, policy and operational matters in conducting our bilateral or multilateral international relationships is, we say, clear and compelling. And that has long been true. And I want to read from Blackstone's commentaries on this matter. Again, I don't invite your lordships to turn it up for these purposes, but it can be found at volume 27 of the bundle at tab 329. And at that point, describing the Foreign Affairs prerogative as, and I quote, wisely placed in a single hand by the British Constitution for the sake of unanimity, strength and dispatch. It goes on to say, and again I quote, with regard to foreign concerns, the King is the delegate or representative of his people. It is impossible that the individuals of a state in their collective capacity can transact the affairs of that state with another community equally numerous as themselves. Unanimity must be wanting to their measures and strength to the execution of their counsels. My Lords, we submit that remains the case. And ours is not the only constitutional system where this is accepted. Other common law jurisdictions recognise similar power for their own governments. In the United States, in Canada, and in Australia, the executive branch holds the power to make and unmake treaties. And these are powers that are used often. In the last 12 months, the government has signed 31 new treaties on a range of subjects, including transport, mutual legal assistance, defence, prisoner transfer, and the environment. They have been used too by the government in playing our full part as a member state of the European Union, including in the process of shaping the development of the EU legal order and all the ebb and flow of EU law rights and obligations which that entails. The government has been doing this since 1972 by participating in Council of Ministers decision-making as well as in the day-to-day transaction of Commission negotiations in Brussels and diplomatically with other member states. And all this, we say, is done using prerogative powers and with Parliament's acceptance. And my second submission is that all this is done as part of the functioning of the UK's dualist legal system. Mr. Eadie will develop this submission in more detail, but I want to give the Court a flavour of it at this stage. It is common ground that treaties are not self-executing. Prerogative actions of the government on the international law plane on the one hand, and on the other, Parliament giving effect as necessary to rights and obligations on the domestic plane, are legally and constitutionally separate. And the EU legal order, we say, is not an exception to that dualist system. It is a clear example of it. To implement the UK's original treaty obligations, the 1972 European Communities Act provided for a conduit for the inflow of the EU legal order. That was its purpose. But the existence of a mechanism such as the 1972 Act for implementing the consequences of EU membership in domestic law has no bearing, we say, in a dualist system on the existence or use of the Foreign Affairs prerogative to remove the EU legal order at international level. That is at least in part because the 1972 Act does not and cannot create EU rights and obligations. It says so in terms, and you will be taken to the relevant language. EU rights and obligations are negotiated and agreed by government and are created and arise on the international law plane. Doing so, we say, involves and has always involved the use of prerogative powers. The 1972 Act provides for the rights and obligations from time to time existing on the international plane to be part of domestic law. Those rights and obligations in domestic law are therefore inherently liable to change, to be expanded, shrunk, or withdrawn altogether by action at the EU level. An action which has that effect, an effect which can include the removal of previously existing treaty-dependent rights, is action taken in the exercise of prerogative powers. And that, we say, is the logical consequence of the conduit mechanism which Parliament brought into being with the 1972 Act. Which brings me to my third submission. Parliament is sovereign. Parliament can, if it chooses, legislate to limit the prerogative, and it has done so. But where it has done so, it has done it sparingly and explicitly, conscious as it has always been of the need for prerogative powers in the effective conduct of government business. So Parliament has considered carefully the proper extent of its involvement in the making of treaties. The provisions in Part 2 of the Constitutional Reform and Governance Act 2010 were the culmination of a lengthy process of dialogue between Parliament and the Executive and of wider public consultation. That Act introduced a series of controls in relation to the ratification of treaties, but it did not introduce a requirement for primary legislative authority, nor did it seek to control the prerogative power to make or significantly to withdraw from treaties. Parliament has also considered, with particular care and in detail, what the balance of legislation and prerogative power should be in the specific context of the European Union. Parliament has done so in a series of acts, beginning with the 1972 European Communities Act and ending with the 2015 European Union Referendum Act. And we will take you to the relevant details of that sequence. But I would make 2 points at this stage. First, there is nothing in the wording of the European Communities Act, or indeed in the later legislation to which Mr. Eady will take you, to inhibit withdrawal from the European Union treaties or subject it to a requirement of prior legislative authority. That, therefore, remains to be done by the government in exercise of well-established prerogative powers. And it is not as though Parliament has been short of opportunities to impose such restrictions if it had wanted to. There has been legislation in 1978, in 2002, in 2008, in 2011 and in 2015, where it could have done so and did not. Secondly, nowhere in the 3 acts that followed the Lisbon Treaty in 2008, 2011 and 2015 is there any basis for inferring a legislative restriction on the prerogative in relation to Article 50 to begin negotiation of withdrawal. On the contrary, we say, close attention to the respective roles of government and legislature in this context has been given by Parliament in each of these acts, and the government's role on Article 50 has been consciously conserved. The last of these acts is the 2015 European Union Referendum Act. That act was passed in the clear expectation, inside and outside Parliament, that the final decision made by the people in the referendum it provided for would be implemented by the government. At the heart of the referendum campaign between Remainers and Leavers was the proposition that the referendum would provide the definitive answer to the question of our future inside or outside the European Union. And the assumption that this was so was surely clear from the vigour with which the campaign was fought by both sides. Parliament passed the 2015 Act and provided for the referendum, we say, in full knowledge that the government had publicly and repeatedly committed to implement the outcome and fully expecting it to do so. We say, too, that because implementation of a decision by the people to leave the EU would require withdrawal from treaty obligations, Parliament expected also that this would be done in the normal way by use of prerogative powers. We say Parliament definitively and deliberately assigned to the public vote and to prerogative action the very question it is said it now needs to ask itself again in precisely the same terms. And Parliament passed the 2015 Act in the clear knowledge and expectation that the process by which the exit from the EU would take place was set out in Article 50 of the Treaty on European Union. It knew what would happen when that process was begun, and it took no step, made no provision, imposed no constraint to prevent the government giving notice to do so in the usual exercise of prerogative power. So, my lords, the triggering of Article 50, we say, will not be an exercise of prerogative power on a whim or out of a clear blue sky. It is the logical conclusion of a process in which Parliament has been fully and consciously involved, a process in which Parliament resolved to put a clear and decisive question about our nation's future to the British people, and in which Parliament expected the government to act on the answer they gave. None of this means, of course, that Parliament will not be closely involved in the process of the UK's withdrawal from the EU over the coming months and years. Through parliamentary debate and scrutiny, through the procedures set out in the Constitutional Reform and Governance Act for scrutinising the withdrawal agreement which Article 52 envisages, and through legislation in the form of the Great Repeal Bill to deal to the extent necessary with the domestic law consequences for former treaty-dependent rights and obligations. Parliament will continue to exercise its sovereignty as it does these things, both when it legislates and when it chooses not to. Because Parliament can demonstrate its sovereignty, we say, as much when it decides not to act as when it acts. Parliament is sovereign to impose whatever legal controls it wishes on the prerogative, and it is sovereign to choose not to. or to rely on political rather than legal controls on the government. That must be what parliamentary sovereignty means. The position of the respondents and others in this case has always been that they have no interest in derailing Brexit, but only in defending Parliament's role in the process. But if this is all about standing up for Parliament, I say Parliament can stand up for itself. When it comes to leaving the European Union, Parliament has had full capacity and multiple opportunities to restrict the executive's ordinary ability to begin the Article 50 process, and it has not chosen to do so. However much they may wish it had, those who support parliamentary sovereignty, should we submit, respect this exercise of parliamentary sovereignty too. And so my final submission, my Lords, is that in the context of this case, the imposition of a legislative precondition by the courts, which Parliament did not choose to impose itself, cannot be supportive of parliamentary sovereignty, but must be positively inconsistent with it. In the delicate balance of our constitutional settlement, this court should, we submit, resist the invitation to make such an imposition. My Lords, as I indicated, there are some further submissions that the appellant wishes to make. Mr. Eadie and Lord Keane will make them. Unless there is anything further I can assist with on what I have said, those are the submissions I wish to make at this stage.
Thank you very much, Mr. Attorney. Thank you. Mr. Eadie.
My Lords, my Lady, can I indicate where my submissions are going to go and give you an overview, if I may?
Thank you.
I'm going to start with 3 brief submissions on the nature of the prerogative. Then I'm going to deal with some basic principles relating to dualism and the impact of the prerogative onto domestic legal rights and obligations. Then I'm going to take you briefly, because I know you'll be well familiar with them, through some of the cases dealing with the de Casa principles. And then I'm going to have a slightly longer section trying to apply both of those sets of basic principles to the context that you have before you today, before turning finally to 2 topics, one of which the Attorney has already flagged, namely parliamentary sovereignty, and secondly, asking the direct question, which the Divisional Court treated as being in effect dispositive, namely, is there a background constitutional principle of the kind that they described? That is the structure, and even in describing it, it appears that my submissions to you are going to be longer than they ordinarily would be, but the complex issues in this case perhaps lead to that. But I will bear clearly in mind what I have been told, which is that in order to maintain the broader interest, if there is any, in the issues in this appeal, these submissions have to be marginally more entertaining than the run that Serenading the Stars is about to make in the 1150 maiden stakes at Lingfield Park. I am not optimistic on that front, but with that lead-in, could I turn first to the prerogative? 3 basic points, if I may. They are general in nature, but they are, I respectfully submit, important to emphasise at the outset of this appeal. Firstly, the point that the Attorney has already flagged, that the prerogative powers are, we submit, an essential and fundamental component or pillar of the modern British Constitution. But one only has to list the paradigm examples that the courts have given of prerogative powers to appreciate that constitutional fact. War and peace, the conduct of international relations, including the powers to make and unmake treaties. Those are powers that are exercised today and that have for years been exercised by the government. It probably matters not whether that is a good thing or a bad thing. It is, we submit, a basic constitutional fact. And it's not difficult, if one had to justify that, it's not difficult, particularly in the sphere of foreign affairs, to see why, under our Constitution, such powers continue to be exercised by the government. subject, of course, to the limited and specific control that the legislature has seen fit to impose upon that exercise. The conduct of foreign affairs involves myriad decisions, a daily exercise of power, a series of judgment calls, the negotiations between sovereign states on the international plane leading to the conclusion and indeed to the withdrawal from agreements that are so made. It was, we respectfully submit, properly described by Viscount Radcliffe in the Burma oil case, Core Authorities, Bundle 3, Tab 34, MS 1356 at page 118, as a power to act according to discretion for the public good. And there has been a recent article exploring the question in justificatory terms, good thing or bad thing, the prerogative, by the Professor of Legal Philosophy at Balliol, Oxford, Professor Endicott. And you have that lecture, which we recommend as at least interesting reading, behind tab 11 of the little blue file, for which apologies, but the little blue or black file, I think it may be, on your desks, with 11 KBW written on the back. That's it. Tab 11 is Professor Endicott, if you want. I'm not going to take you through it now, but
thank you.
There it is. And he relies upon, amongst other things, the very section from Blackstone's commentaries that the attorney has just taken you to.
Yep.
I say an essential and fundamental component or pillar under our Constitution, but we are, as the attorney has already flagged, not alone in having that system, in having the system that we do. Other common law jurisdictions have exactly or precisely similar systems relating to treaty making, ratification, and withdrawal. Specifically, and for example, treaty withdrawal, to focus on that for a moment, is a decision taken by the executive alone in Australia, in Canada, and we cite the Turp case. I'm not going to take you to it. Authorities 26, tab 308, 8950 in the electronic, and New Zealand. And the same position exists in...
Can I just ask, the Tur case does interest me. Are you going to come back to that at some point? Because that's an unusual example of the prerogative being used, in fact, to go against a specific act of Parliament on one view of the matter. I don't know whether you're going to come back.
My Lord, I can come back to it.
Yeah, or perhaps later on.
Yeah, very well. I was saying that the same position exists in relation to the United States, where treaty ratification is subject to two-thirds majority Senate approval. That's ratification. But the power to withdraw vests exclusively in the executive. And you have got in the bundles, it is perhaps worth turning this up very briefly. I'll try and keep the authorities I take you to an absolute minimum, given the time, but this is perhaps of some interest. Authorities, bundle 27, tab 332, and it's 9367 on the electronic.
Thank you. Yes.
And the passage that it may be worth just inviting you to sideline is the passage that you see on page 9367 in the left-hand column,
Yes.
halfway down, beginning termination of a treaty.
Yep.
And again, with my Lord's permission, could I invite you to read that, just that paragraph?
Ending section 332.
Ending section 332.
Thank you. We'll read that. Yes, thank you.
And this first statement of basic principle we submit is enhanced and supported and not diminished by the fact that the powers themselves are ancient.
Could you just tell us what it is that you've directed us to?
My Lord, sorry, my lady,
actually tell us what it was.
My lady, I'm so sorry. That's the third restatement.
On relation,
Exactly.
Third restatement.
It's 9364.
Yeah.
It's the cover page.
I'm so sorry. I should have introduced it.
Yep. Yep.
Thank you.
It is indeed the case that the prerogative powers in question are ancient. What that implies, we submit, is that a long-standing, well-recognised set of powers can properly be recognised as both firmly established in our constitutional arrangements and as having real and continuing value in contributing to effective government. And describing a particular prerogative power as a relic of a past age, a phrase which I know my lords and my lady will be familiar with, needs to be approached with some little caution. That was the statement, or one of the statements by Lord Reid in Burma Oil, and which the Divisional Court chose as their descriptive quotation, if I can put it that way, in paragraph 24 of their judgment. The statement, if one goes back to Lord Reid in Burma Oil, was in fact made in order to justify the correct analytical approach in that case to the nature of the war prerogative, namely, as Lord Reid described it, a historical one, designed to see, in effect, if the government had ever taken property in time of conflict without compensation. So it was a statement for a purpose, implying no suspicion of the underlying doctrine by reference to its age. If describing it as a relic of a past age implies a long history, we agree. If it implies as a general proposition that more today is done by statute and there is less reliance than in Stuart times on the government's prerogative, again, we agree. But to the extent that the description has connotations of anachronism, because the power has existed for many centuries, we profoundly disagree. The correct starting point, we submit, is not suspicion of prerogative powers accompanied by judicial concern to limit their exercise. It is quite the opposite. It is a recognition that the prerogative powers that remain in the hands of government are fundamental to our Constitution and effective government, or essential to effective government. And that properly leads to the exacting tests that I will come to, that the courts have developed before a conclusion can be reached, either that the powers have been taken away or limited by Parliament. I'll come back to the case, obviously, in the rigour of that test. My submission is going to be that the rigour that imposes is sound, or that the powers should be subjected to a broad general limitation in principle imposed by the courts. That's the first submission, therefore, fundamentally. The second submission is that prerogative powers are, by definition, those powers that can be exercised by the government without statutory authority. They do not depend for their existence or their source on legislation. Otherwise, they would be and become statutory powers. So statutory intervention into a sphere in which prerogative powers are exercised involves a legislative decision to impose limits or to abrogate or to remove existing, properly sourced elsewhere, prerogative powers. If a limitation on prerogative power is asserted, such as the interposition of some form of requirement of parliamentary involvement in decision-making in the sphere of the prerogative, decisions will necessarily, therefore, be necessary as to the precise nature and effect of any such limitation. And CRAG, the Constitutional Reform and Government Act, is an example of this. Preceding CRAG, and I'll come back to it, as you will recall, there was much debate about the precise extent and nature of the parliamentary controls that should be imposed on the exercise of the prerogative, and detailed provisions, a detailed position was arrived at. So these too are factors, we respectfully suggest, that indicate that clarity of parliamentary intention is necessarily to be looked for if the assertion is made that the prerogative has been controlled a fortiori abrogated. The third submission in relation to the prerogative is this. Parliament is, of course, sovereign. It can choose to limit, it can choose to control the prerogative power in any way or ways that it sees fit. And, of course, ultimately, it can choose to remove such power in any particular context altogether. So it is accurate, and more accurate certainly in the context of foreign affairs than using relic language, to describe the prerogative, again Lord Reid in Burma Oil, as, quote, part of sovereignty which Parliament has chosen to leave in the government's hands. That's 1338 in the MS numbering, Core Authorities 3, tab 34. Thank you. And in the context of foreign affairs and treaty making, there has been specific recognition of that fact, i.e. that that sort of prerogative power is left in the hands of the government by Parliament in the Bill of Rights itself, as noted by the Court in the McWhirter case. Again, I don't invite you to take it up, but that was a case in which there was an unsuccessful challenge made to the government's signature of the Treaty of Rome, and the relevant reference for your note is Core Authorities 3, tab 46, MS 1849, at paragraphs 6 and 8. Again, what this indicates and emphasises is that the continued existence and exercise of prerogative powers, such as in the conduct of international relations, is constitutionally sound and not suspect, and is in nature subject to parliamentary control when Parliament chooses to do so. But the premise or the basic constitutional default position is the continued existence of these fundamental powers, and that renders it just as important in the context of an argument about limitations on prerogative power to examine and take into account what Parliament has not done. Legislative intervention is necessary, we submit, to limit or remove. It is not necessary to leave the prerogative power in place to be exercised in the usual way without further parliamentary authorisation. So those are the submissions we make, the basic submissions we make about the nature of the royal prerogative. Can I turn to the second of the topics, which was the basic principles relating to dualism and the impact of the prerogative on domestic legal rights and obligations.
Can I just interrupt again?
Yes, of course.
Will you be coming back to the extent to which the prerogative is reviewable by the courts? Because I think this is an area which is touched on in some of the submissions.
My Lord, I think...
Whereas, I mean, some years ago, it would have been assumed it wasn't justiciable at all, whereas more recently, in cases like Abbotsbury and Sandford, we have accepted the power to review, and something we might like to look at.
My Lord, you have. I wasn't proposing to devote a lot of time to that. You will have seen that below there was a flirtation, if I can put it that way, with the non-justiciability argument, and that is no longer being mounted before this court. We accept that the prerogative power, including the prerogative power to exercise foreign relations, may raise non-justiciability issues, but in a context such as this, which raises the fundamental and basic legal question, namely whether the prerogative exists or has been abrogated, it is appropriate for the court to rule on that issue. My Lord is entirely right.
I mean, why it may come in, and we can see how this goes. When one's asking what difference does the referendum make, then arguably, if the government said we're going to get out of Europe without any parliamentary mandate at all, or indeed in the face of an adverse referendum, that might well be said to be an abuse of power, which is reviewable on that basis by the courts. Whereas, alternatively, when it's doing, as you say, something which has actually been anticipated by Parliament, then it's not an abuse of power.
Yes.
And I mean, it seems that distinction might be worth investigating. It's
yes, and that is a point I'm going to come back to when I consider the 2015 Act.
Yes.
But the basic proposition that we accept is that that exercises of prerogative power, subject of course to the non-justiciability limitations that continue to exist, the subject matter is open but only to some extent. The courts have been very, very wary, obviously, a series of cases Lord Carlisle springs immediately to mind. They've been very, very wary about second-guessing policy judgments made by the government. But matters of the kind that my Lord raises, particularly in the context of the 2015 Act, we respectfully submit that if it has a chime, it is probably there, so that if the government acted in a way that could properly be described as abusive, at least arguably, that would be a matter competent, at least, for the courts to consider. Basic principles in relation to dualism. Obviously, I'm going to have to come back and develop some of these themes as I go when we go into the statutory scheme, which is going to occupy a little bit of time later. But I wanted to set the scene first by taking you to some basic constitutional principles on dualism, then some basic principles on decasa, see how those two marry up, and then go to the statutory scheme and show you how that flows, if that's a convenient course. That seemed the logical way of doing it. So 5 short basic points around dualism and the impact of the prerogative on domestic legal rights and obligations, if I may. Firstly, we submit that prerogative powers may be exercised to create international legal effects on the international plane. When the government makes a treaty, it binds the United Kingdom, it acts on behalf of the United Kingdom, and it binds the United Kingdom to that agreement on that plane. And it does so by exercising prerogative powers. As the now famous quote from Lord Oliver, which I'll come back to in the J.H. Rayner case, Core Authorities 3, tab 43, 1779, and the electronic numbering is the key page, or 1778 to 9, now engraved on all our minds. We've set out the relevant quote in our case at paragraph 41. But as that quote acknowledges...
Forgive me, Mr. Eadie, I'm back at references.
I'm so sorry.
Is it 343 or is it 543?
It's Core Authorities 3. Do you have a set of files called CA?
On the electronic bundle?
On the electronic bundle, it's 1697.
It's 543.
I think you're saying it's bundle 3, tab 5. I think that's the...
No, it's volume 5.
It's volume 5.
Well, there's a distinction between core authorities and ordinary authorities.
It's volume 3. It is. Anyway.
It's volume 5.
Well, anyway, let's page.
I'm sorry, it's just confusing.
No, it is. It's in many places, I'm afraid. I think in the core volumes, at least, they've maintained consistency with the MS numbering.
Yeah.
If you just take up the hard copy for a moment, those who have a hard copy.
The tab numbers are the same, aren't they?
The tab numbers are the same, which is why it jumps in the core. If you go to core volume 3 in the hard copy, I should have started with the bewildering nature of the bundles.
I don't think we've all caught up with the core authorities.
Okay, well, they're quite useful because
very useful.
They are a proper dragging out from a wholly obese set of other bundles of.
Well, that's very kind of you, Mr. Eadie. I just wanted to reassure myself that I wasn't looking at the wrong thing.
No, you're definitely.
Because the volume numbers were different. But of course, it's a very sensible thing to have done, especially for those who are not using the...
Well, it means you don't have to lug 5 boxes around, which I've been doing most of the weekend. Core Authorities 3 in the hard volume, if you will, just to show you how it works and where it is, and I'll do it once and then we can pass on, as it were. Tab 43, and you will see in the hard copy it jumps from tab 34 to tab 43. That, however confusing, is deliberate.
And that's page 1778 that we look at.
1778, but it's the same. If you go into volume 5 and whatever, etc., it's exactly the same.
Well, thank you for the explanation. It's very helpful.
Sorry.
Now we know where we are and we can carry on.
1778 to 9, my lady.
Yep.
Creating effects on the international legal plane was really the first point, and that's acknowledged by Lord Oliver in the famous quote. The royal prerogative embraces the making of treaties. And, of course, the royal prerogative also means that the government can withdraw from treaties in accordance with their terms or with general principles of international law in the same way. As Lord Templeman put it, also in the Tin Council, the J.H. Rayner case, this time at 1755, don't invite you to turn it up if you'll note it's there. He said the government may negotiate, conclude, construe, observe, breach, repudiate, or terminate a treaty. That's the first proposition, effects on the international plane. The second is that the United Kingdom system is a dualist system. And that means that there is a distinction between the ability to create legal rights and obligations on the international plane and the transposition of those rights and obligations into domestic law. Treaties are not, in the trite phrase, self-executing. They do not automatically become part of UK domestic law when made. And so the government cannot, without parliamentary intervention, to take that phraseology also from Lord Oliver, alter domestic law by taking steps on the international plane to make treaties. They require instead the intervention of Parliament in order for domestic law to be altered. And that position was, we submit, accurately stated, unsurprisingly, by Lord Hope in the Privy Council in the Roberts case, which you have in the little black file with 11 kbw written on the back of it, which doesn't have MS numbers, I'm afraid, but it's the Roberts case in the Privy Council, which I know my lady was also a member of that court. Supplemental tab 9. The facts don't terribly matter, but it was an extradition context in an appeal from the Bahamas. And some people were wanted for suspected drug trafficking by the United States, who made a request for their extradition to the United States from the Bahamas. But the relevant paragraphs for our purposes are 9, para 9 on page 4, page numbering on the top in the middle. Just to see the shape of the argument, you see halfway down para 9 it says, he also submitted that as legislation was necessary to enable effect to be given to a treaty in domestic law, Parliament had to pass an enabling statute before it was ratified, the it there being the international agreement between the Bahamas and the United States regulating extradition. And then that leads into the statements of general principle, which you see recorded by the Privy Council at paragraphs 12 and 13. Could I just ask you to cast an eye over those rather than my reading them out?
Yes, of course. Yes, thank you.
The third proposition is that, consistently with dualism, legislation then creates, by whatever means, a conduit between international and domestic law, if domestic law is if the international agreement is to sound in domestic law. But the fact that Parliament needs to do that consistently with dualism and has chosen to do that consistently with dualism tells one nothing beyond that a conduit is required. It does not imply that Parliament, by creating the necessary conduit and recognising thereby new legal rights and obligations in domestic law, has also intended to constrain future government action on the international plane. Lord Oliver did not state or come close to suggesting otherwise. And there are, of course, as you will be aware, various ways in which Parliament may choose to transpose from the international to the domestic planes. We give examples in our case. Just turn that up so I can take this tolerably quickly. We give examples in our case at paragraph 43, or volume 2, the first tab, and in the electronic it's page 12342. I don't dare say thousands. 12342.
I'm sure you're right.
test the system to destruction by the end of this case. I suspect.
Yes,
You are right.
paragraph 43.
You are right, Mr.
I am right. Good. At least that's something.
On this point.
I wondered how long it would be before it came. Paragraph 43 is the one I'm after.
Yep.
It gives the examples, including the examples of transposition, how that can be done, the various ways. You can make legislation with no reference to the treaty rights and obligations that are being transposed. The Criminal Justice Act of 1988 about compensation for miscarriages of justice is an example of that, no reference to the treaty at all. You can give effect, but in effect in the legislation's own words, indicating as you do that you're giving effect to the international agreement or instrument. EU directives are perhaps a paradigm example of that. Or, HRA, one can simply schedule the treaty rights in their own terms and then say they are to have effect in domestic laws. There are a variety of different ways in which it can be done. All of those models create domestic legal rights by transposition, and none of them, we respectfully submit, does anything to constrain. There's no implication in any of those that in some way, shape or form Parliament, by having chosen those models or any particular model, has sought to constrain or has impliedly constrained government action on the international plane thereafter.
Is each model a statutory model?
Each model is necessarily a statutory model. It is.
Does any of your three examples cater for a situation where the continued operation of the domestic legal provisions is affected by whether or not the international position remains the same?
My Lord, none of those three does, and of course I'm going to come to that because that is the basic 1972 model. So I'm going to come to that. But the point that I'm on at the moment is the prior point, as it were, which is that there are various ways in which this can be done. And the question is whether in relation to these other models, which do not directly create that sort of situation, whether in relation to any of these other models there is some form of implication that by having introduced the conduit, there is an implication that Parliament thereby intended that you couldn't do anything on the international plane thereafter. Of course, they don't have a direct impact, and I'll come to that. But we do respectfully submit that it is at least of some interest to recognise that if another set of models is used, no implication, as it were, of continuation of said rights would flow.
No implication of continuation
of the rights thereby transposed. They would simply exist on the domestic plane,
yes,
because Parliament has legislated, and the government could do whatever it wished on the international plane, but it wouldn't obviously sound into the domestic scheme. So, for example, if one takes a directive imposes an obligation of result as a matter of international law. The usual way of doing that is to introduce domestic regulations, and the domestic regulations would continue to sit irrespective of whether or not the directive formally finishes, begins, is amended or ends. It would require some other act. And they are, of course, different from the situation that we are dealing with, but we respectfully submit that it's at least of some interest. That's the position in relation to those sorts of models, and that there isn't any necessary implication to be derived from the mere fact that that a conduit is necessary, consistently with dualism, and has been created by Parliament. And of course, I emphasise, to flag submissions that are yet to come, but I emphasise that this sort of implication or inference from what Parliament has done is not, we will be submitting, at large. There are a set of principles that have been developed by the courts to govern the nature of any such inference or implication. My submission is going to be on Decasa, that before you conclude that a prerogative power has been taken away, that needs to be done by Parliament either expressly or by necessary implication. So it isn't just an inference which is at large, and that feeds into the other point to bear in mind, which I'll come back to, which is that if Parliament wants to go to the point of preventing the creation of legal effects on the international plane, it does so specifically. Look at Cragg, look at the bespoke controls under EU law, and so on, which I'll come back to. That's the third of the submissions, the third of five, as it were, on the basic position on dualism.
Yep.
The fourth is that the dualist principle is not that prerogative acts on the international plane can never create effects in domestic law, including the removal of rights and the imposition of fresh obligations as a result of action on the international plane by the government. It is plain that in a variety of more or less direct ways, such acts can have an impact into domestic law. Again, I'll come back to it, but we give a series of examples of that sort of situation, those sorts of effects, including citing Post Office and Estuary Radio, which I'll come back to, in paragraph 40 of our case. So there are a variety of more or less direct ways or indirect ways that action by the government can affect domestic legal rights. And again, just to jump ahead, Post Office Radio, which I'm sure you will have seen or will recall, involves someone broadcasting a radio station from some territorial waters. The government effectively defined where the territorial waters began and end, or begin and end, and those territorial waters were then extended by prerogative act, the consequence of which, under the relevant legislation, was to render criminal the continued publication of said radio station from where the boat was located. So more or less indirect ways they can, the prerogative can have those effects.
That's just another example of your pro tem argument. The rights are, under the statute, or the obligations are, whatever, or relate to whatever the scope of the territorial waters is from time to time.
It is an example of that, and it is a, whether one puts it directly alongside or as a slightly more indirect version of the next way in which Parliament can do that, which is parliamentary intervention, the point that my Lord Mance was raising a bit earlier on. Parliamentary intervention can be done so as to make express provision, the effect of which in domestic law is without more to give domestic legal force to the exercise of prerogative powers. And I will, of course, come back to the 1972 Act and other similar models, but that is one of various models of transposition. And the effect of that sort of model, perhaps the fourth, I gave you three before, this is the fourth, in other words, direct legislative impact and effect to actions by government on the international plane, but it gives domestic legal effect to what may be described as an ambulatory system created on the international legal plane. The body of rights and obligations, the entire legal structure or set of structures on the international plane may change from time to time. And the domestic legislation on this model makes provision for transposition into domestic law that is characterised by the fact that it is both automatic, no further parliamentary intervention required, and direct in terms of impact on or alteration of the scheme of rights and obligations.
This is your paragraph 44, is it?
My Lord, this is our paragraph 44, exactly so, casing it in the case. And the key points we respectfully submit about this model are that Parliament thereby creates a system under which rights and obligations alter and shift. A right, to focus on that rather than an obligation for a moment, may be amended or changed by prerogative action. It may be removed altogether by prerogative action. But all of that is done by the exercise of prerogative powers without further parliamentary intervention. And
is it a question of the true construction of the legislative provision, the relevant legislative provision? It is.
It's a question of construction of that, it is. But it is of the very essence of this model, if this is the model that you're dealing with, that government can, under our constitution, entirely lawfully take steps without further parliamentary authorisation, derived, of course, from the initial intention being, as my Lord has correctly pointed out, that being the intention of Parliament, but the government can entirely lawfully take steps without further parliamentary authorisation which directly alter domestic law, including by removing rights. the possibility of subsequent alteration or removal of rights is inherent in the method of creation of domestic law under this model. That's the fourth point.
Yep.
The fifth flows from it. It is that the nature of domestic legal rights recognised under this model of transposition is contingent. Such rights are inherently limited. That was the description of Lord Millett, writing obviously extrajudicially, in a recent article which is in Bundle 34, tab 471, at electronic page, I think it must be supplemental 1154, so SUP 1154, as the electronics go crazy. So the rights are inherently limited. They have no existence independent of the international legal position from which they derive. And what that means is that the legislation transposing them from the international plane into the domestic legal plane is a necessary but not a sufficient matter for their existence. And they are also in nature susceptible to change as a result of the exercise of prerogative powers, precisely because they are dependent on steps taken on the international legal plane where it is the government that acts.
Yep.
And so they are indeed, if one jumps forward a bit to the 1972 Act, which I will come to in detail in a moment, they are indeed rights that are dependent on Section 2.1 of the ECA, as we'll see when we come to it. But that is but one of the twin ingredients necessary to sustain their existence. The other is dependent on the shifting international legal picture, shaped as it is by the exercise of prerogative power. So Section 2 of the ECA does not define the rights or shape them so as to require alteration by further legislative intervention, or so as to create an inconsistency with statutory rights if the government exercises its powers on the international plane to remodel or reshape EU law. And of course, the rights are dependent not merely on the prerogative acts of the government on the international plane, but also the acts of other sovereign actors. We give in our case at paragraph 51 the hypothetical example of Greece leaving the EU, with the impact on free movement rights of UK citizens that would necessarily have. And a real-life example is the departure of Greenland, within which, should they have chosen to do so, UK citizens could no longer exercise their treaty rights, and the leaving of which was subject to a withdrawal treaty given effect to by an order and not by primary legislation. And you have that order, if you want it, in Authorities 19, tab 233, MS 6656.
I'm sorry, could you say that again, please?
Yep. The Greenland order is in Authorities Bundle 19, tab 233, MS 6656.
Thank you.
6656.
56. I think I gave you a wrong reference in relation to Lord
You did
Millett.
earlier on, but we found it out.
1155.
Yes.
My lady found it first.
Well, that's why we need to know how to navigate, and then because you can't get everything right all the time, Mr. Eady.
Even on some points, perhaps. In relation to the hypothetical example of Greece leaving and the real example of Greenland leaving as illustrations of the broader proposition, which is that they're not merely dependent on prerogative powers by the UK government, but also other sovereign governments. My learned friend Lord Pannick says, well, that's irrelevant because our constitutional principles regulate the conduct of the UK government and not that of other states. And of course he's right, so they do. But that doesn't answer the point. And the point is that the rights are self-evidently of a very special kind, linked to action not merely of the UK, but also of other sovereign states on the international plane. And it's therefore simply inaccurate, by way of analogy, to treat them as if, in relation to their creation, modification, or even removal, as if they were the same as what might be called purely domestic rights. So those are the 5 points we made.
Is there a distinction between the scope of the rights under the treaties, which, as you point out, is ambulatory, may go up and down, may even be affected by somebody else leaving the treaty, and the existence of the treaties themselves?
Well, my Lord, we know that there are certain provisions in the ECA, when we get to it, that deal with the treaties themselves. But my respectful submission is that in terms of whether or not the government can enter into or withdraw from treaties themselves, the position is fundamentally the same. That goes back to Lord Millet's concept of inherency. It isn't just dependent upon or contingent upon the methods of creation of EU law. It's dependent upon the continuation of the very structures which govern. So we respectfully submit that it's essentially the same principle that governs. I was going to move to the De Keyser principles, the third of the topics.
Yep.
The courts have considered on various different occasions and at the highest level the correct approach in principle to be applied in considering the question whether Parliament has abrogated or limited prerogative powers or their exercise. And again, to try and identify the core principles, if I may, before taking you to, it'll probably only be 3 or 4 cases, the core principles we submit as follows. Firstly,
are these summarised in your case?
I'm not sure in quite the order or form I'm about to do them, but I will locate the bit in the case, if I may. If I can ask someone to find me the most directly analogous bit. Firstly, Parliament can, of course, limit, control or remove prerogative powers expressly. Yep. It is sovereign to decide whether to do so, and if so, how. Secondly, whether it has done so outside that express sphere, and therefore in other circumstances, is a question of statutory interpretation. Yep. I'm told that the nearest is 64 in our case, where we start dealing with De Keyser, 64 and following. Yeah. Thirdly, the starting point is to expect from Parliament and for the courts to require real clarity, to put it neutrally, real clarity before prerogative powers are removed. And there is good reason for that. It is no small thing, we submit, to alter the constitutional balance, particularly one that has existed for many years, by abrogating or limiting long-standing powers, all the more so where they are, as the foreign relations powers are, fundamental and essential to effective government.
Most cases in which statutes have been held to limit the prerogative have been cases where it's done so implicitly, isn't that right? By virtue of the field being at least partly occupied by a statutory scheme. It's never said the prerogative is now abolished. All that's happened is that the subject matter has received legislative treatment.
My Lord, that's true. I don't want to quibble at this stage because I'm going to develop the principles as we come, but covering the field exactly is going to be the submission. But there are cases, including in the specific context of EU legislation, the Rees-Mogg case being the paradigm example of that, in which Parliament, in approaching the concept of necessary in which the courts, in approaching the concept of necessary implication, have effectively reasoned thus. They say, here is Parliament that has intervened expressly to impose a sequence or series of controls on the exercise of prerogative in a particular sphere, so is the next step of the reasoning. One can fully expect them, if they're going to do it in relation to some other matter in the same sort of context, to do so equally, expressly. And we respectfully submit that's the correct reading of Lord Justice Lloyd's judgment in Rees-Mogg. But my Lord is right that in the majority of cases where the issue is controversial, the question has been whether Parliament has, by occupying the field to whatever degree, created the necessary implication. That's why I put it as this third proposition. It was neutral, as it were, to the precise nature of the test. It was one can expect clarity because of what is being done. One can expect clarity because it's no small thing to alter that constitutional balance. Yep. But one can expect clarity for a slightly different reason, which is that clarity is obviously necessary where there are, or there is, a variety of ways in which the powers could be limited or controlled.
Mr. Eady, do you say that the European Communities Act 1972 was neutral as to whether the United Kingdom was a member of the European communities?
We say that it proceeded on the fundamental assumption that ultimate decision on the international plane was a matter for government. And I'm going to come to develop that submission. It was a subject of particular consideration, which I'm going to take you to by Professor Finnis recently, drawing a comparison between, in relation to the long title, but equally in relation to the operative provisions of the relevant legislation, between the ECA and various bits of legislation that dotted around it temporarily, 66, 70, 73, to do with the creation of independent status in the Bahamas, Barbados, and so on. But I'm going to draw that contrast and come back to that, if I may, in the context of the 72 Act.
Very well. Thank you.
I'm simply on Decatur for the moment, if I may.
Yes.
And the second reason for clarity was for expecting clarity and for the courts demanding clarity, because obviously the principles are for you. It is obviously necessary to have clarity where there are a variety of ways in which control could be exercised, could be imposed. Various mechanisms of parliamentary control. What's the nature of that control? Is it primary legislation? Is it affirmative resolution? Is it negative resolution? Is it approval by motion? All sorts of questions that would need to be resolved if control is to be imposed. So that's the third of the propositions. The starting point is clarity, or the expectation of clarity. Yep. The fourth is that it's just as important to have regard to what Parliament has chosen not to do as it is to have regard to what it has done in the context of a particular legislative scheme. So a limited, carefully considered scheme of limits and controls will imply that matters falling outside such limits and controls remain untouched. And that is likely to lead in practice and in principle to a place in which Parliament has evinced an intention in the particular context, if that is so, to control expressly or not at all, to come to the point that my Lord Sumption was putting to me. That's a significant...
This is presumably a harbinger of the point you want to make about the 2008 and 2011 Acts.
They are. They're leading towards those. I'm going to take you through that statutory scheme. Fifthly, if there is no express control and the context is not, as I've just described, in other words, Parliament has already intervened to put a series or sequence of controls in place. If there isn't express control and you're not in that place, the test developed by the courts is whether legislative intervention in a sphere where prerogative powers exist creates a necessary implication. That's the test, that the prerogative can no longer be exercised. In other words, that it can no longer be exercised without prior legislative authority. The necessary implication is, we submit, the correct test. It's the test that's been regularly applied by the courts, and it imports the stringency of logical imperative from the language used rather than mere reasonableness. Again, you need no introduction from me to that test first laid down by Lord Hobhouse in Morgan Grenfell, but that, we respectfully submit, is the nature of the necessary implication test. And the necessary implication flows, again, to finish the answer to my Lord Sumption's point, it flows, if at all, from the fact that the very thing the very thing which had been previously done by prerogative has now been, to use the phrase that we'll see in the case law when I come to it in a moment, directly regulated by statute. And the sixth of the propositions, before coming to the case law, is that in approaching the issue of whether or not the prerogative continues to exist at the point at which the power is to be exercised or is proposed to be exercised, it is necessary to consider the scheme of the legislation as it exists at that time. Because legislative schemes can change from time to time, and the question is a current one. And that is the conventional approach. The set of principles that I've just outlined, we respectfully submit, is the conventional approach that the courts have developed over the years for asking the question whether fundamental prerogative powers existing under our Constitution have or have not been abrogated. And it is to be acknowledged as such. In other words, it's to be acknowledged as the conventional approach directly relating and directly addressing the principles that apply in answering that question. I fully appreciate, and I'll come back to it, that the key focus of the respondent's case is whether there is another principle or set of principles in play in the present context to do with affecting statutory rights as a result of the exercise of prerogative powers. But the conventional approach remains, we submit, of critical importance as the correct approach, and in any event in testing whether a principle of such clarity and such weight of the kind for which the respondents contend is properly applicable in our context, in effect to reverse that conventional approach. In effect to say it is no longer a question of asking whether Parliament has expressly or by necessary implication removed the prerogative. Now, if this other principle is in play, that test is in effect reversed. And it is said you have to ask the question the other way around and point to, or be able to point to, express powers in legislation permitting you to interfere with rights. So it does involve a pretty much direct reversal of the conventional approach set out in De Keyser. Can I invite
a circumscription of the prerogative by implication, and the Act which brings about that implication is repealed. Does the prerogative power revive? Is it resurrected?
Well, my Lord, it can do, is that I think the logical consequence of my submission, because it's a current question. If I propose to exercise prerogative power on behalf of the government, what the courts need to do is to ask the question, does that prerogative power exist today? Of course, there are some circumstances where when the prerogative has been put into abeyance, it doesn't come back. But if it is fundamentally dependent upon the nature of the legislative scheme, that we respectfully answer to my Lord's question is a current question. I'll come back. I'm going to develop submissions to whether or not, because on one view it's fairly critical, because it's jolly difficult, we will respectfully submit, for my learned friends to answer the flow of the legislation that follows the 1972 Act. The high watermark of that case is the 1972 Act, because it doesn't contain the great scheme of controls that Parliament subsequently developed. And you know from reading the Divisional Court's judgment that they effectively treated as legally irrelevant for this purpose any act that followed the 1972 Act. We respectfully submit that's fundamentally wrong as an approach. But I'll come back to develop that submission if I may. I was going to take you to De Keyser. It's in Core Authorities Bundle 2, tab 10, MS 228. And the essence we submit is in, just for my Lord Clerk's note, is in the quote from Lord Parmore, which we have set out in our case at paragraph 66. Thank you. But the basic points we get from this I've already summarised, if the statute directly regulates the source of the authority becomes statutory, it ceases to be the prerogative, and then is subject to such controls as Parliament has specified. But it is the direct regulation of the very thing which creates the necessary implication of legislative abrogation or control. And so it requires, as essential to this approach, a precise identification of the government activity, and then ask the question, has that very activity been subject to new statutory conditions governing its exercise so as to lead to that implication? And of course, so as to avoid having to repeat it as we go through, the precise activity in question is the withdrawal from the treaties on the international plane, or more directly, the giving of the Article 50 notice. So when we come to our legislation, that is going to be the key focus. You know, I hope and think, if not, someone better shout, but you know the background and the nature of the facts. The Army Council requisitioned a hotel for the use of the Royal Flying Corps, and it denied the hotel owners a right to compensation. Compensation which the claimant said was due to them, and the Crown in the House of Lords claimed that the right to requisition was a right to be found and sourced in the prerogative, and the prerogative did not carry with it the burden of compensation. And so a critical question was whether or not the requisition was entitled to be done in exercise of that prerogative, for which no compensation was payable at all. And the speeches are interesting because they indicate the test which is to be applied in answering the question whether the prerogative has been abrogated or supplanted.
Do the speeches proceed on the assumption that that was correct, that the royal prerogative existed to requisition property in the UK in wartime without paying compensation? Do they proceed on the assumption that that's correct, or do they discuss that?
Well, I think they do a bit of discussion of that. My lady is right to draw me up. They do a bit of discussion of that, as it were, phase one of the analysis, and then phase two says, assume for the sake of argument that that is so, that the prerogative would otherwise exist. And it's the sort of question that was discussed in the context of foreign requisitions in Burma oil, as you will recall.
Well, that's why I'm asking.
Quite. But in relation to this, they do discuss that question, but then go on to consider, well, assume even that the prerogative was ever of a nature that allowed requisitioning without compensation. Mm-hmm. Has that now been subjected to conditions as a result of the introduction of legislation? So my lady is right to draw me up on that. But the key part for our purpose is perhaps the second phase of that analysis. In the first of the speeches by Lord Dunedin, and the key passage or passages are, I'm going to go on the MS numbering, if I may, so bottom of the page, yep. 246. Yep. Yep. And you see about 5 or 6 lines up from the bottom of the first full paragraph, a line beginning equally certain. Yes. To pick up that sentence there, nonetheless, it's equally certain that if the whole ground, so I've circled whole ground, if the whole ground of something which could be done by the prerogative is covered by statute, it is the statute that rules. On this point, I think the observation of the learned Master of the Rolls is unanswerable. And then you see the question that was unanswerable towards the end of that paragraph. Then there's a definition of the prerogative. And then you see, picking it up again, 3 lines up from the bottom, or perhaps you might read that sentence about 5 lines up from the bottom of that page, inasmuch as the Crown is a party to every Act of Parliament, it's logical enough to consider that when the Act deals with something which before the Act could be affected by the prerogative, my lady's question, and specifically empowers the Crown to do the same thing. but subject to conditions, the Crown assents to that, and by that act to the prerogative being curtailed. So it's direct overlap. They're concentric circles. The whole ground, the same thing. And that leads Lord Dunedin to his conclusion, which is that the Act of 1842, which provided for compensation, and indeed the Act of 1914, which was neutral on the point, did indeed cover the whole ground. It allowed the requisitioning to take place, but it effectively said, if you're going to requisition, you better pay. And you can't get round that statutory regime by relying upon prerogative power. You see his conclusion most clearly expressed on this point at page 248, just before the end of the long paragraph occupying most of that page, about 7 lines up. It is therefore impossible, in my opinion. Yes. Do you have that? Could I invite you to read from there to the end of that paragraph? Yes. So that was Lord Dunedin. Lord Atkinson, if you want it, there's a little bit explaining why the 1914 Act doesn't alter that, but that's over on the next page, about a third of the way down, but not central to the reasoning. Lord Atkinson is next, and the relevant parts of his speech are really on page 259 to 260. Thank you. And can I invite you to read, again, rather than my reading them out? I'm sorry, it may be difficult to follow for those who are just listening, but it's about a page worth. If you go to page 259 and you go to the first full paragraph, I further concur with him. Could you read from there to the end of the first full paragraph on the next page?
Right. You want to sit down while we do that, you're welcome. Thank you. So we have something on answer to Lord Kerr's point there about while it is still in force.
Yes. Yeah. Lord, yes. I mean, the bits I was going to particularly invite you to circle, as it were, and the only thing that changes is the precise description and the fact that it's sometimes plural and sometimes singular. The first of the paragraphs I invited you to read, the one beginning, I further concur, 3 lines up from the bottom of that, yes. The very things.
Yes.
Next paragraph, 6 lines down, the line beginning, of its prerogative to do the very thing.
Yes.
2 lines up from the bottom of the page, particular thing.
Yes.
Which becomes plural in the second line of the first full paragraph on the next page, particular things.
Okay.
But it's all the same point.
It's all the same thing.
It is.
Okay.
So that's Lord Atkinson. Lord Moulton, 274.
Yes.
Again, a similar analysis, 274. The key bit is probably the second full paragraph on page 274, asking the question that it does in the final sentence.
Yes.
And then essentially the same reasoning that we've just seen in the remaining paragraph on that page.
Okay, thank you.
That's the relevant bit in him. Lord Sumner, 281. And again, could I invite you just to read down the first full paragraph, or the only full paragraph on that page, 281. Could you just cast an eye down to, and you can stop at the word speed, 3 lines up from the bottom of the page.
Right, thank you. So it's subject matter rather than thing.
It's subject matter rather than thing, but it is still directly deal.
Yep, thank you.
Yeah.
Yes.
It is essentially the same reasoning. And Lord Parmore, finally, 295 to 296.
This is the passage you quoted.
This is the passage we quoted in our case. You perhaps don't need it, but just for your note, there it is.
Like endless concurring speeches.
All expressed in subtly different ways, but substantively the same as the submission.
Yes.
That is, therefore, De Keyser. Laker Airways is in the same volume of authorities behind tab 12, starting at MS 307.
Thank you.
And again, the facts will be very familiar to my lords. This involved the government effectively trying to use the prerogative to give, in effect, a direction to the Civil Aviation Authority to frustrate or terminate the ability of Freddie Laker to run Skytrain between Stansted and New York, in circumstances in which there was an express legislative power which was subject to conditions which could have been used. That's the summary of the facts. Can I take it first, try and deal with it quickly, take it first in the judgment of Lord Justice Roskill.
307.
So 307 is the first of the pages. Lord Justice Roskill, at page 382. Thank you. Where he identifies the issue at the letter G, the sole question. Do you see that by the letter G?
Yes.
So that just frames the issue. Just that sentence will do for that purpose.
Thank you.
Then he sets out on the next page, 383, at letter E, what he describes as the relevant principles upon which the courts have to determine whether prerogative power has been fettered by statute, were exhaustively considered by the House of Lords. Sets out lots of quotes which you've now seen.
Right, yes, thank you.
Principles to be applied plain, 385 at F. And then he proceeds to analyse on the particular facts of that case why it is that the necessary implication arises to preclude the exercise of statutory power. And the key reason it might be thought is 386 between F. In short, I do not think the Attorney General's argument that the prerogative power and the power under municipal law can march side by side, each operating in its own field, is right. Can I just ask you to read from there to the bottom of the page?
Yeah.
So it's the same, it's just simply an application of the principles that he's taken and considers to be plain from the House of Lords speeches in De Keyser. As you'll see, it's not very difficult to understand how the direct regulation, the same thing, all of those principles, all of that approach is applying.
Is it quite on those lines? I thought that this was a slightly different application or possibly principle. The fundamental reasoning was that having gone through all the necessary statutory hoops, the airline had received a licence, and this was then being nullified by the government by using a power which it had to withdraw designation under a Bermuda Agreement with the United States, thereby, by the back door, undermining what it had done by the front door.
And Lord, it's in part that. You're right. It's a slightly more subtle, as it were, application of the same thing. But it also had an element of direct De Keyser, if I can put it that way, as you see on 386 between B and C. because the relevant legislation did indeed provide for power in the Secretary of State to revoke the licence.
Under Section 4, yeah.
Under Section 4, and what was being done was to exercise the prerogative power alongside, as it were. So, but my Lord is right.
But only in certain circumstances.
Only, exactly, subject to the limitations that Parliament has imposed. So there's a bit of direct decayser in that way, and there's a bit of the point that my Lord put to me in between F and G. I perhaps should have took it a bit quickly. You should have taken you to between B and C as well, but you've got a bit of both in there. And then Lord Justice Lawton, to similar effect, and you probably ought to read between H on page 391 down to D on page 392, just to get the essence of his reasoning. See in particular that between C and D, he's centrally focused on what I call straight decayser.
Necessary implication, yeah.
Exactly, necessary implication, but also reliance, focus particularly on Section 4.
Understand.
Lord Denning, well, I've come to him last, but I have. Lord Denning at 370.
I think the A, the passage on which the respondents rely.
Quite, but that's why I invited you to read the whole passage. It's got to be read in context.
Can't use the Crown powers in this sphere to take away the rights of citizens.
In circumstances in which, as we then see, Section 4 provides the right to revoke the licence, and Parliament has subjected any such deprivation to statutory control.
Yep. But presumably the same reasoning would apply even if there hadn't been a statutory right to revoke. They would simply
because you'd be frustrating. You'd be cutting across.
Yes, you'd be cutting across. So that's an independent line of reasoning to the one you referred to under Article 4.
My Lord, it is, but we respectfully submit it has effectively the same source and drive, which is parliamentary intervention in the field of scheme of regulation and so on. It isn't, and I should have picked up directly, my Lord is right, but it isn't simply, as it were, and as a freestanding principle, the point between A and B. That needs to be read properly in its context, is our submission about that.
You're going to take us to Lord Denning.
I was going to take you to Lord Denning, 370H.
Lord Denning was sort of rather, perhaps not in the majority on this one.
No, which is why, that may explain why I've taken you to him last, but I can't remember quite on this point. But the essence of his reasoning was similar, at least. 370 at H.
Yeah.
Over to C on the next page. We've got back door and front door, which is always an attractive submission.
Side wing, back door and front door.
Might be thought to echo strongly in Lord Denning's mind, but one also has the could he displace the statute by invoking a prerogative? Yeah. See that question, that rhetorical question.
Yeah. Okay.
Ex parte Fire Brigades Union, same bundle, tab 15, MS 444. And this also is subtly different in terms of the facts, because you'll recall the way in which the issue arose. It's really decayser by analogy rather than directly, because the legislation in question wasn't in force. But the court was concerned with a situation where Parliament had legislated for the way in which the Secretary of State was to act in order to achieve a particular objective, there setting up the criminal injuries compensation scheme. But the Secretary of State had sought to achieve different results through the exercise of the prerogative and setting up an ex gratia or a slightly different tariff form of scheme, and had then deliberately, as it were, decided not to bring in the relevant legislative provisions. and I perhaps only need a couple of short bits from fire brigades. 483, using the MS numbering in the speech of Lord Brown Wilkinson. 483, it's really the bit between D and that paragraph beginning by the letter D on page 483, culminating in the citation of De Keyser.
But again, it's a different principle, or certainly a different ambit to the De Keyser's principle. They actually say, don't they, two of the majority, Lord Brown Wilkinson and Lord Lloyd, that this is, De Keyser's Royal Hotel doesn't help in this case. The case is being decided on a different principle. If you look at 553G and 573C.
My Lord, yes. But that's because the statutory provisions aren't at that point in force.
Yes.
So it is by necessity, as it were, De Keyser by analogy. But the reason I took you to the passage between D and F on 483 is because he's there citing the basic approach in De Keyser and setting out the principle that applies. Of course, the position is here that the legislation isn't in force.
The principle being implied is that you can't use the prerogative power to undermine a right or an obligation, isn't it? In this case, it was an obligation to consider bringing into force the legislation.
Well, my Lord, ultimately, if the legislation had been enforced, or if the legislation was enforced, it would be direct De Keyser. So you can't you can't use the prerogative to undermine the law of the land. That's the general principle. And everyone accepts that. That's uncontroversial. The question is how it applies. You can do, see Lord Oliver, if there's parliamentary intervention, as he put it. So, but the reason I keep going back to 483D to F is because it sets out what De Keyser's principle, what De Keyser does stand for, which is where you have got legislation in play. The test is expressly, or as he puts it here, by implication.
So are these three cases anything more than interesting examples of the application of the necessary implication test?
My Lord, I respectfully submit not. I'm sorry it's taken a long while to get to that point, but I did want to drive home the idea that it was expressly or by necessary implication as a scheme, and then everything else flows from that. You can take it by analogy the next stage on, or you can apply it directly. But in the end, it is the same thing. It is the same beast, the same principle. And the vice, it might be thought, in Fire Brigades Union, to come to its specific facts as an example, and the reason why Lord Brown Wilkinson ultimately decides as he does, one sees from 485 between G and H. And that's really the nub of the objection, the last two sentences of that paragraph. By introducing the tariff scheme, he debars himself and so on. That's the essence of it. And we see that also from, in terms of the final reference here, from Lord Nichols at 509 at F, between E and F. Perhaps if we could pick it up between E and F, the line beginning, the inescapable conclusion is that the Home Secretary has effectually written off. Next party, Rees-Mogg, then, if I may. Same bundle, tab 14, MS 424. And you see the context from the head note. I just invite you to cast an eye down there to get the... This was all about Maastricht and whether or not there were powers to sign up to various protocols that were part of the Maastricht Treaty. And the key passages for our purposes are start on page 439.
439.
439 electronic, under the second issue.
Yes.
And just so you see it, can I invite you to read that page and a half, or a bit more than page and a half, under the second issue before you get to the third issue on the next page.
Thank you. Yep.
And so we respectfully submit that the key paragraph for present purposes, which is the primary basis for rejecting the argument, is the paragraph at the bottom of page 439. So they're unable to accept the argument that Lord Panic was mounting.
Do you submit that that means that there is a difference in the test to be applied, depending on whether we're talking about the prerogative to make treaties or unmake them, or other aspects of the prerogative, as we've seen in the cases you've just cited? In general, it's an implicit displacement by statutory intervention in the relevant field. But is it your submission that there is a tougher test to be applied for this particular prerogative power?
My Lord, there's a tougher test to be applied in accordance with this reasoning, not so much because it's treaty power, although it was treaty power there, but because Parliament had intervened in the area in which the prerogative was exercised to impose a whole series of controls already. And that carried with it, as it were, the implication that if it was going to intervene to control that sort of action, it would do so expressly. So it's almost an aspect of...
It's a sort of exclusia unitas.
Sort of thing,
yeah.
Exactly. It's almost that. But it does say you've gone in there, you've designed the scheme of control. Having gone there and designed the scheme of control, you can draw the inference, if you will, that if Parliament's going to control it, it's going to do so expressly. And that's exactly the sort of thing one would expect if what you're dealing with is a beast which requires decisions to be made of a legislative kind around things as basic as what should the mechanisms of control be? Should there be primary legislation? Should there be affirmative resolution? Should there be motions to which Parliament consents, and so on? But that's the point that is being made. And my learned friend below, and I think the Divisional Court accepted this, said, well, no, you can pretty much bypass that paragraph with that reasoning in it, because, as they ultimately go on to conclude, the protocol on social policy, and this is the remaining part of the analysis under the second issue, they then conclude that that protocol wouldn't in any event become part of domestic law, so where's the worry? But my respectful submission is that that's a second strand, a distinct strand of reasoning, and it doesn't touch, because it provides simply a distinct reason for reaching the same conclusion. It doesn't touch the reasoning that one sees in the final, which is, it might be thought self-evident, which one sees in the final paragraph on page 439.
So, I mean, just to be clarified, it's not your case that the treaty-making prerogative is subject to different principles.
It isn't my case that treaty-making prerogative, just because it's treaty-making prerogative, is subject to a different set of rules on the back of this paragraph. The point we respectfully...
Generally.
Or generally. I mean, I'll come to develop that argument in case I'll come to develop that argument. But the point that is being made here is not dependent upon it being a treaty, but is dependent upon the fact that Parliament has chosen to intervene in the way that it already has. It's that creates the inference that if it's going to do so again, it will do so expressly, because it will be altering the nuance scheme that it has already designed.
Can I just ask you where this fits into the scheme of your submissions as a whole? Does one not have to ask first, what is the nature of the prerogative power? Is it a prerogative power which authorises one to do things on the international plane which do not have the effect of altering domestic law, or is it a general prerogative power? The reason why that matters is that if the prerogative power never did extend to doing something that altered the domestic law, then no question of abrogation arises. You arrive at a situation where its exercise would alter domestic law, and you can't do it, not by virtue of any implied statute or express statutory provision, but simply because of the conditionality of the prerogative right one's talking about.
My Lord, yes. I think the way I'd answer that is that there are two different beasts in play in our particular context. And the first of them asks, what is the usual way in which the courts, and what are the principles on the basis of which the courts seek to answer the question whether or not the prerogative power has been abrogated? And the second of them asks, what is the nature of the 1972 Act, to which I'll come, and the way in which it has set matters up, so that effects on the international plane are directly and automatically introduced into domestic law. So, of
before
course,
you get to that, you surely have to ask, what are the limits, if any, of the prerogative power to make and unmake treaties? If the position is that the prerogative power is only as broad as it is because the assumption is being made that it doesn't alter domestic legal rights, then one may well arrive at a situation in which you just never get to the question what the statute says, unless it is being suggested that it actually confers a prerogative right to change the law which wouldn't otherwise exist.
Well, I see that.
I don't think
I see that as a prior question, but we respectfully submit that the prerogative power in the field of making of treaties, ratification of treaties and withdrawal from treaties is and always has been a general power, untrammelled by any such implication, which has, and I'll develop this in a variety of ways, impacts into domestic law through any or all of the various models that we've analysed in our cases. So although I see the force of asking that as the prior question, as it were, or as a prior question, we respectfully submit that that's a question that's got to be answered, recognising that, A, it's a general and untrammelled power ordinarily, and so if you get to the stage where you're saying, well, is there a freestanding principle that would control it in limine, you have to answer that question and ask that question in the context in which it arises, and recognising that exercise of prerogative power can and do have impacts into domestic law. That isn't to say you don't still go back to the statutory scheme to see whether there are limits on that Parliament has imposed.
But what do you mean by impact on domestic law? Do you mean actually changing the content of domestic law, or do you mean simply altering the facts to which an existing principle of domestic law applies?
Well, it could be either or both.
They're very different things.
They are very different things, but it could be either or both, which is why the ambulatory scheme and how the 72 Act works and all of that is thoroughly important. I accept that one isn't necessarily dealing with the same beast when one's considering post office radio or matters of that kind, or even the argument that my Lord advanced in J.H. Rayner, which was fundamentally premised on drawing that distinction between factual matters that sound in international legal facts, as it were, and other matters. But I accept
this is the fundamental distinction between you and the other side, isn't it? I mean, do you start from the proposition that there is a well-recognised power to make and unmake treaties, and the only questions are, is it subject to any statutory restriction, express or implied, or subject to some common law principle such as abuse of power? Exactly. Alternatively, as my Lord puts to you, you ask, well, is there actually such a power at all if it has the effects on domestic rights?
And one answers that question by looking at the way in which prerogative power has operated in the
I understand how you answer,
yes.
but it's, there's obviously the alternative view, which is diametrically opposed.
Yeah. My Lord, that's Rees-Mogg, unless anyone wants more on Rees-Mogg. Just before short adjournment, can I deal with, just by way of mention only, I'm not going to take you to them, but if you still had the will to look at other authorities on the basic approach to abrogation of the prerogative, Northumbria Police Authority, which you'll recall was all about police ordering various bits of equipment. That is perhaps worth a read. It's in Authorities tab Bundle 8, tab 77 at MS 3059. Mm-hmm. And a recent case which involves the exercise of prerogative powers by the Home Secretary to remove people's passports, cancel or withdraw passports, XH. Currently, we only have the judgment in the Divisional Court, and I'm threatened with the Court of Appeal next week, comprising inter alia the Master of the Rolls and Lord Justice Sales, who will no doubt be therefore familiar with the basic Decazar principles. But that also is of some interest, at least.
Where is that?
In analysing that. Core Authorities, Bundle 4, tab 66, 2781.
You say there's some interest. Do they take this any further forward, or are they more of the same?
They're really an application.
Right.
It's an application in a different context. I hesitate to take you to it because my Lord Wilson raises a fair point. I can go to all these cases. And
they're
just different illustrations of the same basic approach and principle.
Yes, I see. Yes.
But it's an interesting analysis there, and it contains, if you want it in a convenient place, Lord Hobhouse in Morgan Grenfell. But the relevant paragraphs for present purposes are really from 39 to the early 50s. 52, I think.
Do I get the impression that this is a convenient moment, Mr. Eadie?
Lord, it may be a convenient moment. I was going to go to the principle of legality, but
Let's leave the principle of legality for 2 o'clock. We'll rise now and we'll resume it. Court's now adjourned. Ms. Reedy, a word about timetabling before you start. We're due to start at 10:15 tomorrow. One of us has a medical appointment that means that it's possible we'll start a little bit late. If we do, I apologise in advance, but and if you have until 1 o'clock, and if you lose 10 minutes at the beginning, we'll sit into lunch to make up the 10 minutes if you need it.
I'm very grateful. We shall try to avoid that disaster if humanly possible.
Disaster may be a little high, but depends how much you care for your lunch, I suppose.
The principle of legality. Still under the broad heading of the De Keyser principles, how the two marry up. We respectfully submit that the approach in De Keyser has at least some similarities to the principle of legality, but what the De Keyser principle does is to focus on the fundamental importance of the rights of government to act in the public interest for the overall good in exercising prerogative powers such as in the foreign affairs context. And it requires, similarly to the principle of legality, real clarity before those powers are taken away. In that sphere, in other words, considering whether or not the prerogative power has been impinged upon, the courts do not approach the question whether the prerogative power has been interfered with or abrogated by asking simply whether or not that power has the capacity to affect rights. We know that it does in a variety of different ways. And indeed, many of the cases in which the De Keyser principles were hammered out involved precisely that feature. Many of those cases were precisely about the use of the prerogative to interfere with rights, including common law rights to property, as the paradigm example in De Keyser and indeed in Burma Oil itself. The principle of legality is also, you will know, a rule of statutory interpretation designed essentially to control, as an aid to interpretation, generally expressed powers conferred on government by statute. And here we submit the question is not as to the breadth of generally expressed statutory powers. It is different. The question is whether or not Parliament has abrogated the prerogative which sits alongside the legislative schemes, impinging, as they sometimes do, and to various different extents, onto that territory occupied by the prerogative. So that question is answered naturally, we submit, by examining the legislative scheme as a whole against the constitutional backdrop we've described. So it's fundamentally different, we submit, from the principle of legality. Lords, my lady, I was going to take you next to the fourth topic, which is the application of the basic De Keyser and dualist principles in the present context, and that obviously starts with the nature of the statutory scheme. So apologies, it's taken a bit of a lead-in to get there, but the statutory scheme, I can start it here with CRAG itself, 2010 Act, which is in Core Authorities Volume 1, tab 5, MS 131. I'm so sorry, 131.
We start here, not with the 1972 Act.
We start here just because this is a general scheme of control. That's the logic of it. A general scheme of control by Parliament over treaty-making powers. Treaty-making and all other things to do with treaties.
Was this the first time any such scheme, general provision, had been enacted?
Exactly so.
It was basically, to some extent, a statutory codification of the Ponsonby principle.
That was going to be the first point. Yes. It is exactly that. And you have the Ponsonby memo, if you want it, in Bundle 15, tab 158, MS 5038.
Thank you.
But it does exactly what my Lord the President has just described. It involves, in effect, Parliament considering, for the first time we note in 2010, but Parliament considering the controls that it wished to impose generally in the context of treaties. And the upshot is, as we see, you may or may not have had a chance to glance at it briefly, but it's in, effectively, Part 2, which are the only bits I hope that are in your bundle, of CRAG. There is, I should point out at the outset, there is a cutout from Cragg for treaties to which now the European Union Act of 2011 applies, as you see from section 23(1)(c. So there's a separate regime governing controls, which I'm going to come to in a moment. In the
Sorry, can you give me that section again,
of
please?
EU treaties, 23(1)(c.
Section 23(1).
Can you say what did it say originally in section 23? Would you remember which provisions were specified in it? Presumably the 2008 Act.
10, it probably would have been the 2008.
Could you
I will get the original for you overnight. I'm pretty sure it would have been the 2008 Act, because that's the next one in the sequence after that is 2011, which would have post-dated this.
Yep.
So there's a cut-out for treaties to which that applies, and there is detailed provision made for the particular kinds of parliamentary influence over the prerogative powers hitherto untrammelled, as it were, to do with treaties. So in section 20, just to show you very briefly what the scheme involved, subject to what follows, a treaty is not to be ratified, so it's a control over ratification, unless, and then you see the mechanism of parliamentary control that is imposed, which is the laying before Parliament of a copy of the treaty, 20 sub 1A, something allowing potentially the public to get engaged in the debate in 20 sub 1B, treaty being published in the way the Minister of the Crown thinks appropriate, and then effectively negative resolution, 20 sub 1C.
Thank you.
Then period A, so that's 21 days for a negative resolution to be put into place, and the consequence of the House of Commons resolving that it doesn't wish the treaty to be ratified is then dealt with in subsections 4 to 6. But you see from that you've got the negative resolution procedure, then effectively you've got a two strikes provision, so that the Minister of the Crown can relay, this time explaining why it is that they want the treaty ratified, and then they get another 21 days within which that negative resolution can again be exercised by the House of Commons. And then the clarification in 6 that it can be done, a statement can be laid on more than one occasion. So that's what happens if the Commons votes against. You get another go, and then the Commons can vote against again if they wish. But it's effectively a double negative resolution procedure. And then in 7 and 8, they make specific provision for what happens if the House of Lords resolves that it doesn't want the government to ratify the treaty, but the House of Commons is content, effectively.
Yep.
And on that occasion, the consequence is that in sub 8, the treaty may be ratified. That's if the House of Lords have voted against, but the House of Commons have voted, or are content, as it were. The treaty may be ratified if a Minister of the Crown has laid before Parliament a statement indicating the Minister is of the opinion that the treaty should nevertheless be ratified and explaining why. So there isn't a double whammy on that occasion. There's simply a burden of explanation under this. So that's what happens in relation to the general scheme of ratifying treaties. You don't need to worry too much about section 21. But all of that, in other words, the scheme that I've just identified in section 20, is subject to the exceptionality provision in section 22.
Yes.
Of course, the Minister of the Crown would rationally have to conclude that the matter was exceptional, but if he did, then the process is a different one. You don't have negative resolution if he decides that exceptionally it should be ratified without them being met, so, for example, on time grounds or whatever else it may be, some other exceptional reason. You don't have the negative resolution process, but you do have the duties that are imposed by 22 sub 3. just for the sake of completeness, there's a burden or a duty to produce an explanatory memorandum, 24.
So basically this works on the basis that the Parliament's given an opportunity to jump in and say don't do it.
Exactly so, subject to the well, even within section 22 it might be thought. They could still say we insist. That would be within their power.
22 too. Yep. Okay.
And treaty is defined and ratification are defined in the manner that you see in 25.
Thank you.
To complete the picture. So we take 3 short points from Cragg. It's firstly significant, we submit, because Parliament has intervened in the area of treaties and decided what intervention in this prerogative sphere it wished to have. And that piece of legislation was the product of detailed and careful consideration with a nuanced set of controls, and those are properly judgments for Parliament to make, as it has done in this piece of legislation. Secondly, the intervention by Parliament, in general terms, in relation to this suite of powers that accompanies treaties, is express and nuanced. It reflects precisely the sorts of decisions that one would expect Parliament to make and consider if intervening in this sort of context to alter the usual position, namely that the Crown exercises those prerogative powers as it sees fit in the public interest. It applies to ratification of treaties. It leaves untouched negotiation or making of treaties. And it produces a considered system of controls dealing precisely and in detail with the form of control that Parliament wished to exercise. And you've seen the layering and the subtleties of all of that. Laying a copy, subjecting it to negative resolution, exceptionality procedures, all of that. There are a series of decisions about the nature of the parliamentary control that Parliament wishes to impose. And the third point is the obvious one, that it includes no requirement, even for limited forms of parliamentary involvement, in decisions by government to withdraw or commence the process of withdrawal from treaties. And that is so, we add in brackets, even though withdrawal might have impacts on rights and obligations on the international and domestic legal planes. So there's therefore, we submit, a considered decision by Parliament to leave withdrawal to the government in the usual exercise.
Well, what was the origin of this? Is there some sort of paper behind all this?
Behind Cragg?
Yeah.
I'm sure there will have been a white paper and there will have been debate in the usual way.
Well, you've told us that it was all carefully considered, so presumably you've got evidence for that.
Well, my Lord, my Lady, we'll check overnight to make sure you have the white or the green papers, whatever there was.
It doesn't say anything about rights, domestic rights, does it? It's the ratification leaves completely unaffected how the treaty will take effect, if at all, in domestic law.
That's true. It is fundamentally a control of the exercise of the prerogative powers on the international plane.
But there would have to be domestic legislation. And by the same token, I mean, it doesn't deal at all with what the withdrawal from a treaty, what the effect of that would be on domestic rights.
It doesn't deal with transposition at all. If one examines these as two separate elements involving, on the one hand, as it were, the exercise of prerogative power on the international plane, giving of notice, whatever it may be, the withdrawal from a treaty, the ratification of a treaty, there's a separate set of questions around transposition and impact into domestic law.
But do you think, I mean, were these issues, do we know, discussed in a white paper of any sort?
In terms of transposition, yeah. I doubt it, because this is simply designed to control the exercise of those prerogative powers in that way on the international plane. But we'll check.
Just going back to your ambulatory rights, there is a whole framework, which I think is not reflected in the papers at the moment, involving liaison between the government and Parliament and involving parliamentary scrutiny by the European committees, both the House of Commons and the House of Lords. And that's subject to the now published Cabinet Office guidelines. Now, that enables parliamentary input into changes in the
rights and obligations, which you described rightly as ambulatory. Is there any equivalent system of liaison and supervision in relation to a decision to withdraw from a treaty or to exercise the royal prerogative in any other respect?
Not as far as I'm aware, but we will, again, if we need to, we can pull together that raft of documentation and just double check. So not as far as I'm aware is the answer to that, but I'll check. But that's Cragg, and my Lord Carnwath is right. It goes to the exercise of these prerogative powers on the international plane. It doesn't deal with or purport to deal with transposition or effects into domestic law or anything of that kind. But it is nonetheless significant because it is the act which controls and exercises parliamentary regulation over those sorts of powers. So it is parliamentary intervention into the field. Yeah. And you have my submission already, the basic submission, which is that the prerogative power is a freestanding source of power. So if Parliament is going to be intervening into that field, it does so expressly, deliberately, and in this sort of nuanced way.
I mean, it also helps you to reject the suggestion that the exercise of these powers in the foreign plane is somehow a sort of hangover from medieval times.
Quite so, because this is a 2010 piece of legislation.
We know it has some introductory notes, because the notes say it, but we haven't got them either.
I'll let you haven't got that. Again, we'll check if there's anything relevant in there. Yep. I'm told we've got the green papers and the white papers in the bundles. Tells you all you need to know about the weight of preparation. Can we get the... We've got the green paper is in bundle 15, tab 166, MS 5189. The consultation paper is at 167, tab 167 in the same bundle, bundle 15, MS 5213. Thank you.
What was the first reference?
5189, 15166.
5189 and then 5213.
Yep, thank you.
166 and 167 within bundle 15.
Thank you.
The European Communities Act 1972, to go back in time, tab 1, within Core Authority, Volume 1, and page 17, as originally enacted. You've got the current version if you want it in the next tab, but for present purposes it may be sensible to view it as enacted.
Yep.
Sorry, which one is as enacted?
As enacted is 1, tab 1, MS 17.
Okay.
And then MS 54 behind tab 2 is current.
Very well. Yep.
Make a general and overarching point, first of all, in relation to the 72 Act, which I know you will have read, which is that it made no provision whatever regulating any future decision to withdraw from the EEC treaties. And that was so even though withdrawal was well within the contemplation of Parliament at the time of the passing of the ECA. As the Divisional Court correctly acknowledged, there was debate in the Divisional Court around how that might occur, but at least if all parties consented, it was plain that withdrawal could occur, as the Divisional Court accepted correctly at paragraph 56 of their judgment. Indeed, it is notable that the European Communities Act 1972 places no restrictions at all on the treaty prerogative in the EU context. And there is a real and serious contrast between that fact and what Parliament chooses to do when it wishes to assert control over the exercise of prerogative powers in this sphere. See Cragg. Start with the long title. An act to make provision in connection with the enlargement of the European communities to include the United Kingdom, and so on. We submit in relation to the long title, perhaps if I can just break this down into the submissions we make about each of the sections. I know you will be familiar with them and will have read them, but That may be a convenient way to do it. In relation to the long title, we make these submissions. It is, we submit, accurate as a general summary of what the Act does. But it will be accurate in that way whether the government retained its long-established power to withdraw from the treaties or it did not. And there's nothing in the wording of the long title, to put a point negatively, there's nothing in that wording to support the significance that was attached to it by the divisional court we submit. There may be a positive point to be made in relation to the long title. That's the first submission. The second submission is the positive point. It does not state that it is an act for and in connection with the UK becoming a member of the EEC. And nor is there any operative provision in the Act itself authorising the government to act on the international plane to make the UK a member. The wording used in the long title is not the wording, an act to make provision for and in connection with, etc. That is not the wording that is used, and that stands in contrast to precisely that sort of wording, for and in connection with, that was used around exactly this time when independence was being conferred on Barbados, Fiji, and the Bahamas. And that is of interest because those pieces of legislation do dot around 1972. And if you go into the supplemental bundle, the black 11 kbW bundle, you will see the way in which that is done in tabs 1, 2 and 3. So 1 is Barbados, 2 is Fiji, 3 is the Bahamas, and they all use the same words. The dates and the significance of the dates, because they dot around 1972 you see. 66 was Barbados, 70, 2 years before this act, was Fiji, and then the Bahamas was 1 year afterwards. But you see that their long title is an act to make provision for and in connection with. It all is in the same form, just to look at the Barbados one. And then you see...
Well, the difference is the absence of for.
No, and.
For and.
For and, sorry.
For and in connection with. I mean, and that's really leading one in to the point of substance, which is that they then have an operative provision, which is in section 1, effectively. Her Majesty's government shall have no responsibility for the government of Barbados, and so on. So they're then setting out the nature and effect of what legal position is being created, as it were, in that way.
What about the earlier resolution of both houses, which effectively gave the green light to the government to go ahead with negotiations, we have that somewhere in the papers.
You do. I'm going to come to that, if I may.
That, yes.
I'm going to come to that, but I was right. What it poses the question whether the government could have ratified the Treaty of Accession unless and until it enacted the ECA, which is what the Divisional Court concluded. My lord was right. Resolutions, as it were, support motions in the House, but there wasn't an Act of Parliament. You didn't need the ECA to ratify, even the accession treaty to the ECA, to the EEC, sorry. Can I come to that? I'm going to come to it in due course. Just to finish this point, we claim no originality in terms of this point. It's the point that is made and developed in the recent lecture by Professor Finnis, which you also have in that supplementary bundle behind tab 12. And the relevant part is page 11 and following. But the basic structure of this legislation is therefore, as reflected in its long title, and in the absence of any equivalent, as it were, to Section 1 of the independence pieces of legislation, the basic structure of the legislation as reflected there acknowledges that dualism is in play, and that, consistently with the government having constitutional responsibility and the ability to conduct foreign relations, it is for it to make and ratify treaties. So the enlargement referred to in the long title is achieved by Her Majesty's government in the usual way, signing and ratifying the Treaty of Accession. And you have the Treaty of Accession, if you need it, in Authorities 13, tab 141, page 4658. And so this statute uses and is premised on dualism and on the constitutional roles of government and parliament sitting alongside each other. And so everything in Part 1 is about giving domestic legal effects to acts taken in the exercise of prerogative powers on the international plane. That's what Part 1 is about. That's what it does. And its fundamental nature is focused not on actions on the international plane at all, but on the distinct aspect of domestic transposition and the creation of the recognition of domestic legal effects. And we do submit that the Divisional Court was inaccurate to conclude that the government could not have ratified the Treaty of Accession unless and until the ECA was enacted.
Well, they couldn't have. They would have been in breach of a large number of principles of EU law if they had not done so.
Because there was no domestic transposition.
Exactly.
Right.
I mean, that is the sense in which they suggest that they had to do it, isn't it?
Well, my Lord may be right. I thought they were making the rather broader point that we didn't...
They couldn't even assume obligations on the international plane.
Quite.
That's your submission.
Right. Okay. And my submission is that we plainly could. That's the way in which it was going to be done. And that's entirely clear that that power was still left with the government, because when the Parliament truly wants to impose limits, well, making a point in two ways. When it wants to give permission to do something on the international plane, it's perfectly capable of saying, I give you permission to do this, a bit like the Bahamas and Barbados situation, creating the legal effect in that way. But if it wants to restrict action on the international plane like ratification, again, we know that Parliament can do that, and we know that it has done that. We saw Cragg. And then it's got a whole series of decisions it would have to make around what type of parliamentary permission should be given and how that should be, where the balance should lie between the government on the one hand and parliamentary control on the other. We know as a matter of fact, if you go back to the 1972 Act and you see the date on which it was enacted of the 17th of October 1972, we know that the UK instrument of ratification was in fact deposited the day after it was enacted. In other words, on the 18th of October 1972. But that, we respectfully submit, tells you nothing about whether or not the ECA was some kind of legal precondition to ratification, and we submit plainly not. There's nothing to authorise ratification in the ECA. How otherwise could we have committed the United Kingdom on the international plane, other than by way of the exercise of the prerogative?
Okay, no authorisation and no for, comma, and in connection with, only in connection with.
Exactly so.
Yep, okay.
And of course it avoids, as my Lord Sumption pointed out, doing it in this sequence avoids potential breach of international obligations, because you haven't got the domestic transposition that is required.
Yep.
So we respectfully do not accept that there was any need for any of that. And moreover, that the ECA, the 1972 Act, does not require the UK to become or indeed remain a member of the EEC. It can be demonstrated perhaps by asking what the position would have been if the government had not ratified the Treaty of Accession shortly after the ECA came into force, or indeed at all, as was the case with Norway, which signed but didn't ratify. And the Treaty of Accession itself set the date for our membership, if ratified, at the 1st of January 1973. And of course, it isn't a breach of international law, to answer the question posed It isn't a breach of international law to sign a treaty but then not to ratify it. That's precisely what Norway did. But the logic of the respondents' argument is that the government would have been in breach of the ECA. And that plainly isn't the case. Parliament was therefore merely facilitating membership should the government, in the exercise of its treaty prerogative, take the United Kingdom into the EEC.
Isn't this is potentially a Farmers Union case, I think it's suggested, against you in that context, if you might test your proposition or put your question in a slightly more sophisticated way by asking what if the government had announced immediately after the passing of the ECA that it would never ratify the Treaty of Accession. Well, you would give the same answer, I appreciate. You would say that's their choice. Yeah.
That's their choice. And as fundamentally, or more fundamentally perhaps, this is the whole structure, the basic structure of this Act.
Why wouldn't that be potentially an abuse of power as it was?
Well, it could be. One could have that argument, the same as the 2015 Act we were discussing earlier. You could see a claim being mounted of that kind, but the answer that my Lord gives on my behalf, as it were, is one I would give.
But how do you distinguish Farmers Union in this context?
Well, we respectfully submit that that requires an understanding of how this Act is designed to be set up. It wouldn't be, it isn't, as it were, imposing on the government a duty. Otherwise, it could easily have said so. It's simply facilitating. And it sits alongside the recognition that the government exercises prerogative powers on the international plane in that way and always has done.
Exactly what submission are you making on the basis of these statutes? Are you saying that if the government lacked a suitable prerogative power before 2008, the 2008, 10 and 11 Acts implicitly created one? Presumably not.
No.
Now, if in that case, surely we have to look at what the position was before these statutes. And if the position was that the government did not have the power then, the statutes don't help us one way or the other to decide the present issue.
Well, my Lord, I think that's tolerably close to the question you asked me before with a short adjournment, which is, are we starting in the right place before we get to any of this legislative scheme?
It's another possible instance of your starting perhaps in the wrong place.
Right. Well, that was I think, the point you were putting to me before the short adjournment. But my answer to that is that these prerogative powers to exercise international relations powers, to ratify, to negotiate, to agree, to withdraw from treaties, they've always been expressed as general prerogative powers. As it were, they've never been defined by potential impact on rights in that way. So they've been expressed as general prerogative powers, and they've then been regulated by Parliament in a variety of ways. So you've got all the various examples which we'll come to. You've seen Cragg already. And in the treaty sphere, we know that Parliament has regulated those otherwise generally expressed powers very specifically. So the nature and content of the prerogative from the beginning has been a general prerogative power to do these various things, and it is then characterised by different forms of impingement into those generally expressed powers by Parliament, none of which, it may be said, have been defined or set by reference to a potential effect on rights. And we know that the exercises of the prerogative in this sphere, and I'll come back to this because I'm going to have to develop this principally in answer to is there a background constitutional principle, we know that, of the kind the Divisional Court identified, we know that prerogative powers can be and are exercised to have serious impacts, potentially sometimes, into domestic law rights. The 72 Act, as I'll develop in a moment, is a paradigm example, but we have, and I'll develop this, a similar position created when we left EFTA before we joined the EEC. So we've got an example in this Act of that sort of process happening. And we know that double taxation treaties similarly, but I'll come back to all of that probably tomorrow now. But those matters are all there. And it does, therefore, depend fundamentally on analysing what, we entirely agree, what the nature of the prerogative is, but if the prerogative starts as generally expressed, as is our case, and is then impinged upon, then that is the correct starting point. The correct question becomes, what species of control, what forms of control has Parliament chosen to impose upon this exercise? And we know that in relation to leaving, for example, the EU, the only way in which that can be done is by way of exercise of the prerogative.
But, Mr. Eadie, you've shown very convincingly that our entry into the EU was a joint effort. The exercise of prerogative power by the executive and the exercise of legislative power by Parliament.
Yes.
And so, put very simply, one of the arguments that you will have to deal with is, if our accession was the result of joint effort, should our departure not equally be so?
Well, my Lord, the submission I make is that the joint effort, as it were, in the 72 Act is a joint effort in the sense that it assumes that all the prerogative powers continue to exist and be operated. And so all that this is doing, this Act, is not to, well, put it in the positive, this Act is designed, and that's all that Part 1 does, to deal with transposition. It doesn't authorise, it doesn't purport to be a joint effort in relation to the going in. It simply assumes and is premised on the continued existence of that power. And withdrawal, therefore, is entirely consistent, to put it in my Lord's helpful way, is entirely consistent with that framework, because when you withdraw on that basis. You withdraw in exercising the prerogative powers that sit in parallel to and are the premise for the 1972 Act.
I see the force of that, but it's not quite an answer to Lord Wilson's question, is it? Because the way the treaty was signed and then not ratified till Parliament had done its bit in passing the 1972 Act meant that it was very much of a joint effort, to use Lord Wilson's expression, whereas on your analysis, pulling out would not be a joint exercise.
Pulling out would not be a joint effort.
That's the point.
But this, and the fact that it is ratified the day after this Act is enacted, for the reasons I've given, is significant only because it avoids, as it were, the government being in breach of its international obligations once it decides to go in. That's the true significance of it. That's what it's done. As I say, when we get to EFTA, I don't want to get too far ahead because EFTA is quite complicated. We'll try and simplify it overnight. But we get to EFTA, you see that that's how they do it there, as it were. They leave in the exercise of the prerogative, and then sometime later Parliament comes in. But I'll show you that tomorrow. But of course, it slightly depends, I suppose, how one defines joint efforts. But joint effort there undoubtedly was, but only because in Part 1 they're transposing. They're giving domestic legal effect to the rights that are created on the international plane.
As a result of a joint effort between Parliament on the one hand and the government on the other.
Yeah, well, that's the point that my Lord Wilson has put to me.
Well, what's the answer to it?
But the joint effort involves assuming, and this whole Act is premised on, the prerogative powers continuing to exist. This doesn't purport to authorise us to ratify. It wouldn't place us in breach if we didn't ratify. It simply says, once on the international plane, you have entered into the treaty, which was signed some time before. Once you've ratified, then these are going to be the domestic legal effects.
Your argument really is that you needed a joint effort to go in order to get the powers transferred to the citizens of the UK, but you don't need it to come out.
We don't need it to come out because we can withdraw. And again, I don't want to get too political about it, but if joint effort is what's required, then joint effort you have. Parliament decided to set up the referendum to ask the very question. Again, I don't want to get too far ahead of myself because I'm going to come to the 2015 Act in due course. And it doesn't precisely deal with the legal point that my Lord is making, but there is, as it were, constitutionally, the joint effort that is provided by that. But I think my fundamental legal answer to the point my Lord puts to me is this Act is not saying, it doesn't say in Section 1, thank you very much, you're now authorised to ratify, PS Section 2, here's the effect in terms of transposition into domestic law.
Isn't this, to some extent, because we're just looking at the 17th and 18th of October 1972? I mean, if you look back at the history, before the Treaty of Accession was ever negotiated or signed, both houses considered the matter, and in October a year before, 1971, they separately resolved that this House approves Her Majesty's Government's decision of principle to join the European communities on the basis of the arrangements which have been negotiated.
So that's possibly not even that is the starting point, but that's a relevant starting point when you consider this statute. They're hardly going to repeat anything like that in the statute because it's a given. What they're doing is taking the final step to implement quite major changes in rights and obligations domestically. On your analysis, Parliament is effectively prepared, isn't it, to do whatever the government decides without actually expressing a view itself. Is that realistic?
Well, the significance of those motions is, one, they're not primary legislation.
No, of course not.
They're not primary legislative authority, and you don't remove or abrogate the prerogative by passing a motion of that kind in Parliament anyway.
No, but they're background, aren't they?
They are background. They are background, but what the true significance of that, my Lord is right to draw attention to the fact of it, but the true significance of that, it might be thought, is that there are myriad ways in which Parliament, if I use the word neutrally, politically as it were, can exercise control, can give consent, can recognise the significance of an issue. So what is not being done is to say we need primary legislative authority for you to go and ratify this treaty. This Act is not in any shape or form that sort of beast. And my Lord is right to say there were some motions beforehand, but all that demonstrates is that under our Constitution there is flexibility as to how Parliament chooses to get engaged in a particular issue, what steps it wishes to set out beforehand, what matters it wants to debate, and how it wants to go about doing that. And the true parallel, if there is one, once you recognise that it is not primary legislative authority to do the thing on the international plane, the true parallel between the motions that you identify and the present situation involving withdrawal is that here we had the referendum. And Parliament got involved beforehand to set up the referendum, to ask the very question, should we leave? So, as a matter of law, I quite understand why my Lord Wilson asked the question that he does, and I've given the answer that I have. Tried on a couple of occasions to give the answer that I have to that question. But in answer to my Lord Mance, yes, there may be significance in that in the sense that it continues to be a joint effort in a broad sense, because Parliament has chosen to get involved. But nothing in those motions by the Houses of Parliament suggests that it was a legal precondition. Otherwise, it would have been legislation or a legal authorisation. It was simply Parliament expressing its view that this was an appropriate thing to do in the exercise of the prerogative. And the parallel, therefore, with the 2015 Act is exact.
It wasn't, I mean, that was an exercise of the Ponsonbury Convention, wasn't it?
That was an exercise, it was pre-Crag, effectively.
Which, as you say, doesn't apply to withdrawal. But a thing that's puzzling me in relation to Lord Wilson's question is that you, in your case, make something of the fact that there will be parliamentary involvement once the Article 50 notice has been served. And indeed, there's something called a Great Repeal Bill, which the Attorney General mentioned. Do we have any evidence about that?
About the Great Repeal Bill?
Well, yes, about what it is, what it's going to do. Because it seems to have some relevance to ask ourselves, well, what actually is Parliament's role going to be between now and the end of the 2-year period?
Yes, I mean, I'm sure we do, and we'll find. There's been, I think that currently there's simply been a statement by government about what is intended to be covered.
I'm not even sure. I think there's been a statement of the Conservative Party conference. Has there been anything else?
Pass. We'll double check and get you whatever there has been on that. But I think there's no more than that at the moment. There isn't, don't think, a white paper or anything of that kind.
Can we just go back to this point about the 2015 Act? It, in a way, I suppose you would say fits in with the argument that says that if you're right, the day after the treaty had been ratified, on your argument, the government could have had a change of heart and pulled out. the idea of a partnership with Parliament is that in practice that would never have happened without either Parliament approving or without the 2015 Act, which you say, although not as a matter of strict law, was in practice a Parliament's involvement.
Well, yes, and I've hesitated to go back in this case to the quote that you may have seen in our annex from Lord Bingham in the Robinson case about the fluidity of the Constitution. I don't rely upon that because we respectfully submit the position is entirely clear in terms of the existence of the prerogative and how this legislation as a matter of strict law is set up, which is the case that I have to meet. But we do submit that there is real significance in the various and myriad ways in which that partnership, that joint effort, if you will, can operate. It can operate by way of motions, it can operate in the Cragg sense, it could operate in the Ponsonby Memorandum sense that preceded Cragg, or, as significantly, it can operate because Parliament chooses to produce in primary legislation a referendum. And we know when we come to it, 2011 did that in various different respects in the 2011 Act, 2015 Act the same. The difficulty is drawing, as it were, a straight constitutional line.
Because the UK Constitution, such as it exists, is not a straight line. Now, we've not got past the long title because of questions from us. Perhaps we should be moving on from the long title.
Yes, well, it's the long title and what Part 1 does. I don't want to rest too much on the long title because the long title we know is a beast of limited assistance in terms of interpreting, or can be a beast of limited assistance in terms of interpreting, but it's fundamentally what the operative provisions in Part 1 are doing, which are all about transposition and not about regulating international plain action.
Yep.
Section 1, then. Steady progress. Section 1 sets out the mechanisms by which treaties come to be approved and put on the list. And the significance of Section 1 is that the Divisional Court thought that that was a strong indicator that the treaty prerogative generally, including withdrawal, therefore, was controlled by the ECA. But, of course, we submit that the restriction or any restriction on the exercise of the prerogative power to withdraw or to give Article 50 notice simply cannot be inferred from Section 1 of the ECA. By definition, a number of points on that, by definition, we submit, the ECA can't have been intended to abrogate the Article 50 notice power for the simple reason that Article 50 was not even a gleam in someone's eye at that point. And the EEC treaties didn't in terms deal with withdrawal at all. So it can't have been designed to deal with that. But as we've already seen, the Act as a whole in 72 imposes no restriction of any kind, still less of the sort that we see in Cragg and later pieces of legislation. It imposed no restriction at all on action or treaty making or anything else to do with treaties on the international plane. It didn't authorise us to become a member or to ratify, and so we could have, until at least 1978, the next act I'm going to come to, when there was an express restriction introduced into the EU context for the first time, we could have negotiated, agreed and ratified new treaties and hence bound the UK to those treaties under international law without the prior authorisation of Parliament. That isn't, of course, to say there wouldn't be all sorts of very good practical and political reasons for wanting the prior approval of Parliament, but that's a different matter. That broadens the concept of joint venture, as it were, even though the line may not be straight. So this is all about the imposition of restrictions and giving effect at the level of transposition into domestic law. And so we do submit that standard dualist practice, of which this Act is a paradigm example, standard dualist practice simply indicates that there is a need to provide for a mechanism of transposition. And that's what this Act does. And once one recognises that as the fundamental nature of it, it becomes entirely clear that it isn't to do with or seeking to control the exercise of prerogative powers on the international plane. So you have the mechanism that you see in Section 1.1 and Section 1.2 with its references to listed treaties and indeed to ancillary treaties. And then there are mechanisms for introducing new treaties onto that list in 1.3 in the manner that there's been some debate in the past around whether or not 1.3 would operate as the legislative mechanism for simply ancillary treaties or other treaties as well. I think the position that the court arrived at in Smedley was that it applied to the ancillary treaties only. And certainly the position is that subsequently, when treaties have been added to the list, that's been done by primary legislation. But as we see, that may be explained by the fact that there was specific introduction from the 78 Act onwards to require primary legislation whenever the powers of the European Parliament were being expanded. So that might explain why that happened. And maybe at least not entirely easy to see why, as a matter of ordinary construction at least, Section 1.3 might not be taken as authorising both types of treaty addition, both ancillary and listed.
Which was the case you said that treated it?
Smedley, I think it is. I'll find the reference.
Seddon?
Smedley.
Smedley, I think it is.
As I say, as a matter of pure interpretation, it's coming up the thing as a matter of straight interpretation. There is at least a question there. But Smedley appears to have resolved it for the time being. And then we come to Section 2. And the first point to make in relation to Section... I'm sorry, my lady. I'm going to try and speed up a bit, but Section 2 you will all have read. The first point to make about it is that it created the conduit. Yep. And it's the first of 4 relevant points we want to make on Section 2. It creates the conduit. Consistently with dualism, it needed to do so given that the treaties took effect and created rights and obligations only on the international plane. And in that way, Parliament, consistently with dualism, enabled the United Kingdom to comply with its international/EU law obligations. Yep. The nature of the conduit, as we see from 2.1, the transposition model, if you will, was direct and automatic. And what that means is that the rights and the obligations that were created on day 1 could be altered and could be removed by action taken under the prerogative by the Crown. And Section 2 simply sets out the basis of transposition, necessary for all the reasons I've given, but the significance of it doing that and of that being its nature is that it tells one, the introduction of a conduit or a transposition model of this kind, tells one nothing about the discrete issue of some form of parliamentary control of government action later on the international plane. It's simply creating the necessary transposition mechanism. The divisional court attached some significance to the title alongside Section 2, and we've dealt with that in the annex to our case, where we track, as it were, the textual analysis of the divisional court and answer them paragraph by paragraph. I'm not going to spend a lot of time on that now, but it might be thought that in relation to the heading, the fact of the matter is that that heading is accurate and descriptive, and adequate to give a general summary as to what the section is doing. It suggests, if anything inaccurately, that Section 2 is as it were, a consequence of dualism. But it doesn't do more than that. It doesn't carry some form of implementation, that because this is about general implementation of the treaties, that means the treaties must always stay the same or cannot be withdrawn from. Indeed, we know, when we come to it later, as I will do shortly, that we know that when Article 50 does become part of the EU framework in the Lisbon Treaty, it is then added to the list in section 1.2, and Article 50 is thereby given effect, as it were, so that these rights and liabilities exist subject to that. But the general title we submit, the general heading, doesn't avail one.
Does that involve the proposition that Article 50 is incorporated into domestic law?
It's become part of the listed treaties.
But is it incorporated into domestic law by this Act?
My Lord, it's not incorporated by this Act. It isn't. And I don't make that suggestion.
No. Because it only operates
it's not directly effective. It operates on the international plane, but it indicates that the rights and liabilities as they exist from time to time are subject on the international plane to that power of withdrawal.
This phrase, from time to time, that we read twice, rights from time to time created, remedies from time to time provided for.
Yes.
Is that simply talking about changes in European law?
Yes.
Changes from time to time in European law? Or do you say that the phrase also encompasses rights being changed and remedies being no longer provided for as a result of withdrawal from the EU?
My Lord, I respectfully submit that it's a recognition that and I'll come to develop this point, but it's a recognition that the rights that are created are inherently susceptible to change.
But change where?
Change at the EU level, principally, by exercise of government action.
Yes, the Act is recognising that the new source of law is brought into domestic play.
Exactly.
And as well as Parliament and the Commonwealth, you have EU law-making institutions.
Yes, and my Lord used the word recognition, which we respectfully agree with, rather than, as it were, creation, so as to create an analogue with other domestic statutory rights. But it is recognising exactly that.
But I think the point that's being put to you is that this may be concerned solely with variations in the content of EU law and not with the possibility of withdrawal from the whole scheme of EU law.
Well, my Lord, that's right in terms, but it doesn't touch, we respectfully submit, it doesn't touch our power to withdraw, which continues to exist under the prerogative, is the way we put it.
Maybe the position looked...
argument insofar as you advance it.
Well, it weakens it. I'm not sure it does weaken it with respect. The way we put the argument is that we've always had the prerogative powers existing. What this does demonstrate most clearly is that by exercise of prerogative power, the government can affect rights, can withdraw rights, can remove rights in any event. It could remove 99.9% of the rights entirely consistently with 2.2.
Well, you say by an exercise of the prerogative power, the likelihood of the Council of Ministers and now the European Parliament agreeing to remove 99% of EU rights is rather remote, isn't it?
Well, my Lord, it may be rather remote in practice, but as a matter of law...
It certainly isn't done by unilateral exercise of the UK prerogative.
No, and I've made the point already that it isn't only our prerogative powers that are in play.
Yeah, but I think the issue we're trying to focus on is whether you rely for your purposes in this appeal on the words from time to time.
We do.
Because?
Because it demonstrates that rights can be affected directly by the exercise of government power on the international plane.
But there's a huge difference between submitting to the rulings of a club committee as to what the club rules are, the dress code or whatever, if you happen to be a member of a club, and not being a member of a club at all, either being expelled or giving notice. Isn't that the point that's being put to you, rather?
My Lord, it's a scale point. We can affect domestic legal rights and obligations in this way through exercise, albeit not on our own because there are other EU actors in play, We can affect domestic rights in this way by exercising our prerogative powers on the international plane.
But did you say those words really just apply to changes in, as it were, EU rules?
They apply to changes in the corpus of EU law.
Yes.
But what that illustrates is that the powers that exist under the prerogative to engage with Europe in that way to achieve that domestic legal effect continue to inure. And of course I accept that there is a difference in terms of scale, at least, between a withdrawal, a leaving of the club, and a voting about whether or not you should wear a tie in the dining room.
This is
of course I accept that.
It's not really a major point in your argument. Though.
It isn't. Well, it's a major point that this is, two major points. One is that this is a conduit.
Yes,
and
exactly.
a necessary conduit, and therefore...
And this emphasises it's a conduit through which water is going to keep on passing.
Yes, and therefore you don't imply anything about control over exercise of prerogative power on the international plane, because this is simply a conduit.
Yes.
And the second is that the rights and obligations under this provision, created into domestic law once transposed, are capable of being affected, including removed, from time to time, by actions which are, at least in part, dependent, with our other actors, on the exercise of prerogative powers.
Yes, I see.
Maybe the answer to these questions is different as you construe the Act with the additions made in 2008 by comparison with what it would have been before. Although Article 50 only operates on the plane of international law, from 2008 onwards it was plain that if the object of Section 2 was to ensure that the domestic law obligations were no wider than the international law obligations, that included withdrawal after 2008.
Everyone knew they could leave. Oh, yes. And there is quite a fundamental significance to Section 2, which is that, as you will recall, the Divisional Court's judgment is fundamentally premised on the idea that you can't affect, through the exercise of a prerogative, you simply can't do it. That's the background constitutional principle. You can't affect rights in domestic law, and here we know you can. The rights can be affected. They can be altered, they can be amended, they can be removed.
Yeah, but it isn't just a question of scale, it seems to me at the moment. The difficulty you have to face up to, I think, is that what is envisaged is not merely that the size of the stream, as it were, coming down the conduit may vary from time to time, and what precisely its composition is varies from time to time. But you're envisaging making the conduit completely redundant, by the sound of things.
Well, if you withdraw, that is the effect.
Well, that's different in nature, I might argue, from merely a change in the composition of the quality of the water that's flowing down the conduit.
Yeah. But I mean, my lord, I accept you can. I'm not sure much is going to turn on whether we characterise a difference of nature or a difference of scale. It's the same point. Is there a distinction between withdrawal, complete removal of these rights, and not? And that has to be approached in sequence, as it were. The first point is, we know from this, because it's precisely the essence of it, that the government can destroy rights, to use the emotive phrase that litters the other side's cases. We know that they can do that. That's the very essence of this model.
Well, when you say we know they can do it, just explain in what way you say that the government can destroy rights.
Because they can operate on the international plane in the context of the EU to agree to various forms of directly effective measure, regulations, matters of that kind. And the consequence of that may well be that the rights that exist on day one either are altered on day two or cease to exist on day two.
Yes, I mean, they certainly have no right to do it. They may be outvoted in many contexts.
They may be, my lord. All of that is true. Yeah. All of that is true, but it all depends upon the government being able to act within that partnership, if that's the right way of looking at it, on the EU plane.
But that is what is contemplated by this Act, that the government will, under the EU lawmaking institutions, play its part, and that may lead to changes in one direction or another. I think the question is whether what is contemplated by this section also includes withdrawal from the treaties.
I mean, surely you're not, you're here, I think, dealing with the argument.
Let him answer the question.
Sorry.
My lord, there are undoubtedly differences between withdrawal entirely and the affecting of the corpus of rights from time to time. But what it illustrates is that the government can remove rights under this basis, and that fundamentally, we respectfully submit, causes a problem for the reasoning and analysis of the divisional court. When you come to ask the bigger question, does this contemplate withdrawal, my submission is that it contemplates and is premised upon all of the government's prerogative powers on the international plane continuing to exist. That is the fundamental premise on which this sits. I'm going to come to develop the submission in a second, but what that means is that the rights that are conferred into domestic law by this section are inherently limited. And they're inherently limited by the ability to act in concert with others on the international plane under the EU auspices in all the various ways that they make and create rights and obligations from time to time. And it's inherently limited because at a much more fundamental level, all of this is premised on the continued existence of that basic relationship.
Okay, can I put my point? Because I don't quite understand why we're spending so long on the 72 Act. Because, I mean, your main point, you've got to address the divisional court's point that it couldn't affect rights at all, but your main point is that things change in 2008, as my Lord.
2008, 2011 and 2015.
For the first time,
yes.
Get Article 50. And, of course, the key thing with Article 50 is the 2-year automatic exit, which is a completely new feature.
My Lord, yes. I mean, I agree with all of that. Can I just finish the answer on scale, if I can call it that, or scale/nature? And the answer, one of the answers on scale/nature is, or the twin answers are, nothing inconsistent with the continued existence of the power to withdraw in Section 2, because it's premised on the prerogative powers continuing. And if you get to scale and you take into account subsequent developments, you take into account, in addition, the 2015 Act. Now, again, the line may not be entirely straight at that point, but the fact of the matter is that it, like the rest of the legislation, subject to the controls we're about to come to, does nothing to take away or seek to control the prerogative powers that exist, including withdrawal.
As I understand it, sorry to keep on about Section 2, but as I understand it, if it didn't say from time to time in Section 2, your basic point would still hold that nothing in this Act takes away the fundamental prerogative, either by necessary implication, let alone expressly, upon which you rely. And all that from time to time does ultimately is merely to give a bit of support to that argument by the notion that as a result of the government's involvement in decisions in Luxembourg and Brussels, that the laws will be in this country will be changed through the exercise of the prerogative.
Lord,
and that's really as far as it goes.
My Lord, that's,
Is that right?
that's its core significance. Yes, I entirely agree.
Thank you very much.
That's its core significance. But as I say, what it does do is to demonstrate that the rights themselves, just look at it, forget about whether or not there's any implication, because it doesn't deal with withdrawal expressly. No. Of course not. And so the question is, what implication is to be derived from it?
So what?
And the best implication, or the only real implication from it we submit, is not that it controls the prerogative power which sits alongside, but that the domestic legal rights that are recognised in the way set out in Section 2 can be affected by the government acting within those EU institutions.
Thank you very much.
If the government were to give notice, I think it's accepted that before Section 50, the government could have extracted the UK internationally from the European treaties.
Yes.
If it had done so, it would have left a scene where some European Union obligations disappeared at once, others remained as remnants of membership of the community, or all those which required specific domestic implementation, e.g. obligations to give effect to directives, and so on. So, I mean, is that easy to contemplate in the context of Section 2, which contemplates regulations and so on to implement, doesn't have any provision for the event of the prerogative being exercised to disimplement the treaties?
My Lord, yes. We respectfully submit it is consistent, because the fundamental premise for Section 2 is that we continue to be members, and it's dealing with the transposition of the rights and obligations such as they are. The points that my Lord has been putting to me are the mechanics of exit, as it were. We're in that position now, hence, e.g., the Great Repeal Bill, which is proposed, where you put everything that used to be EU law onto the domestic statute book, and it's easier then to pull out and make policy decisions policy area by policy area.
So again, I mean, you say that Parliament's only role is simply to give effect to whatever the executive decides at the international level.
Exactly so. At that stage and at that base level. And if one is worrying about scale, one is saying, well, what implications can we draw from this? You don't just stop here, as it were. You wind the clock on to the point when the decision is actually being made. And Parliament has at that point decided that it should submit that very question with all its implications to the people in the referendum. But there's no implication the other way in Section 2. Indeed, the one thing that is clear, we respectfully submit, subject to acting with others, the point my Lord Manson made, the one thing that is clear about 2 is that the things that the government does on the international EU plane have, as it were, direct effect into our domestic law, including the removal of rights. Right. I suspect the submissions I was going to make on Section 2 can now be rather shorter. But can I just run through them anyway, just in case? The next point I was going to make about Section 2, the first one having been conduit, the next one was going to be that Section 2 recognises rights and obligations created elsewhere and altered elsewhere. In other words, on the international plane. And there are therefore 2 necessary preconditions to the rights and obligations having effect in domestic law. A, the general conduit that is Section 2, and B, acting under the prerogative by the government, shaping and creating, removing and altering that scheme of rights and obligations. So these are, as Section 2 expressly recognises, rights, and as Section 2 puts it, created and arising by or under the treaties. Yeah. That's where they are created and or they arise. And those rights are simply then, again, tracked back to the wording in 2.1, recognised, available in law and enforced and allowed accordingly. The creation is on the international plane, and the explanation for that structure is that treaty-dependent rights are not and could not be created by Parliament, depending, as they do, on international, including government prerogative action. And that point serves to undermine at base, we submit, the truth and force of any analogy with rights properly described as having been created, in the sense of defined, by Parliament on the domestic plane. And of course, rights and obligations created under the treaties, the wording used, includes all the ways in which EU law is created. So it includes regulations which have directly effective legal impact, and where the government acts representing the UK, negotiating and agreeing those sorts of measures. The Divisional Court also relied upon the concept of an enforceable community right that you see at the end of 2.1, and they indicate that it implies, as it were, that community rights would continue. We respectfully respond that the wording and the concept, that definition, was necessary for the structure which transposes rights created on the international plane, as is recognised in that section, and it implies no continuation of those rights. That's the second of the points, as it were. So conduit and rights and obligations, secondly, created elsewhere and altered elsewhere. And flowing from that, the third point, perhaps on 2, is that those rights are in nature inherently limited or contingent, as already indicated. And what that does, once you recognise that they are inherently limited or contingent, is it serves to undermine, we submit, any statement of principle that is expressed too generally, or that it is taken from one context where it may remain true and transplanted into a different context. In other words, if you take the statements in particular, I'll come back to this when I deal directly with the point, take the statements from Lord Oliver, about self-executing treaties and the prerogative not being capable of being used to alter the law of the land. But we know that under this model it can do precisely that. It also strikes fundamentally at the proposition that the giving of notice or withdrawal is in some way, shape or form to be regarded as constitutionally objectionable, because the effect would be to remove rights currently enjoyed under the ECA. So ultimately it would, but that's the essence of the rights created by the ECA anyway. They are inherently limited, inherently dependent upon and contingent upon actions occurring on the international plane.
Yep.
And so one can analyse it, as I think Lord Millett does in his article, on the basis that the withdrawal from the EU and the giving of notice by the government will simply cause those rights to which the ECA gives life in domestic law to expire in the way envisaged by the 1972 Act and in accordance with their terms. It isn't therefore accurate to describe the process of withdrawal, the starting of that process, as in any real sense revoking or overriding statutory rights.
So you would say that Lord Millett's analysis is correct?
We do, and we respectfully adopt it.
It's in the black.
And at a more fundamental level, it's the point I've made already, at a more fundamental level we submit that this recognition of their inherently limited nature, their contingent nature, indicates that all of the rights and obligations to which Section 2 gives effect are dependent upon the continued relationship between the UK and the EU. There's no need to imply anything into Section 2 for that to be accurate. It's simply inherent in the very nature of the rights and obligations that Section 2 creates.
You did give us, Lord Millett's, the reference to his favour before. Can you remind us where it is?
It's 34,471.
Thank you.
11,544.
It's inherently dependent not merely upon action from time to time, but upon, more fundamentally, the continuation of that basic relationship.
Yeah.
It depends upon the maintenance of that relationship. The club's rules apply, and the right to elect people to its institutions, for example, are dependent upon the continued membership of the club. Yeah. It's also to be noted in relation to Section 2 that its effect is expressly limited to giving effect to treaty rights and obligations in the UK. It gives effect to rights and obligations which are, as it says, without further enactment to be given legal effect or used in the UK. It doesn't therefore give effect to treaty rights which are enforceable in or against other member states. It doesn't create a right of a British citizen to live in France, because it couldn't possibly do that. We couldn't legislate for their ability to live in France. That would be a matter for France to regulate. And what that indicates is that the ECA was only intended to implement the treaties in the UK and didn't have the wider purpose of authorising entry into the treaties or creating or guaranteeing the full range of rights arising under the treaties. It's a much more limited purpose. That's Section 2. Section 3, which deals with the creation in relation to Section 3, sorry, I'm just focusing on the points, trying to focus on the points that the Divisional Court made about Section 3, and we've dealt with that in our annex, paragraph 5, bracket 7. I don't repeat that. It no doubt does assume the existence of issues of EU law which the CJU can deal with, but it doesn't imply or state that the rights and obligations under EU law continue to exist. It tells one nothing other than, for as long as we're members of the EU, there needs to be an institution which resolves issues about rights. So those are the core provisions of the 72 Act. And just before going to the remainder of the sequence, as it were, there is a question which hangs over the remainder of the EU-based legislation here, which is that if the 1972 Act had the effect of removing prerogative powers to act in a variety of ways in relation to the EU law structures, if that was, as it were, removed or taken away by implication, then it's jolly difficult, it might be thought, to see what the later legislation is doing with its nuanced scheme of control over that very thing.
Isn't the point to put against you on that is that it's dealing with or addressing increases in European competences and rather than diminution?
Well, it is in part doing that, but we'll see when we get to the scheme of control that it's actually imposing a whole raft of controls in this entire area. Maybe that's the fundamental political driver for some of it, the ever-increasing expansion, as it were, of EU law, but that's a matter of law. It's pretty much a specific aspect of the point I've already made in relation to Cragg. It's Parliament's considered decision-making as to what controls it wishes to impose in this context. And the first of the later pieces of legislation is in the same core volume, but you jump forward to tab 112, so it's core volume 1, tab 112. Page 4218. And it's the 1978 Act. And this is an important step, we submit, because for the first time, Parliament decides to control an aspect of the treaty prerogative. In other words, it decides to control how the government is able to act on the international plane. And it does so expressly. If you go to page 4219, Section 6 required primary legislation to be passed before any treaty increasing the powers of the European Parliament could be ratified. So that was an express and a specific and limited control of the treaty prerogative. Parliament decides what element of the treaty prerogative it wants to limit, and it chose the ratification of particular treaties, and it chose the form of control of primary legislation. So if the treaty prerogative has been excluded, then this limited form of control, but this very specific form of control, becomes difficult indeed to explain. And that had two important consequences. The first, and for the first time, the Crown is no longer free to exercise the treaty prerogative however it chose. This precedes Cragg by some years, you'll recall. It couldn't any longer agree and ratify without prior reference to Parliament in this specific context.
And the second... It could agree, it couldn't ratify, is that right?
It could agree, it couldn't ratify, exactly.
Yeah. Yes, I see.
And secondly, it explains the subsequent chronology of parliamentary involvement. After this Act, Parliament always passed implementing legislation for the major new EU treaties before and not after they were ratified, but the reason for that is because Section 6 meant that Parliament had imposed itself into the process.
Yep.
So that's the 78 Act.
Right.
Then there's 2002, which is actually in the supplemental bundle, sorry, the little black 11 kbW bundle. It was omitted because it was replaced in the 2011 Act, but just so you see the sequence, it's tab 4.
Thank you. And that's similar to Section 6?
Virtually identical. It was reenacted in Section 12 of the 2002 Act, But of course, the significance of it, the added significance potentially, is that the 78 Act was in 1978, and we're now in 2002. Yep. Yeah, the Assembly have become a Parliament, but the time period is of interest because Parliament has now seen numerous major treaty revisions negotiated by the Crown under its prerogative and has chosen not to implement any further restrictions on the prerogative treaty power. This simply replicates Section 6 originally passed with slightly different language in 1978. So that's the 2002 Act. Back to Core Volume 1, if you would, and Tab 3. This is the European Union Amendment Act of 2008, MS 117. And it incorporated Lisbon. And the features perhaps to note are these. In Section 5 on MS 119, it altered the position that we've just seen in Section 12 of the 2002 Act, expanding the circumstances in which primary legislation was required before ratification of any amendment to the founding treaties made by ordinary revision procedure. Yep. So there is an example of primary legislation, primary legislative authority being required by express provision. But note, in relation to a very specific matter, that this piece of legislation also had to consider and deal with Article 50. And Article 50, we know, did not pass unnoticed. If you could keep that open, but briefly go to Authorities, tab 30. Sorry, Authorities Bundle 30, tab 402.
MS.
Those are the explanatory notes.
It's the MS.
MS number 10346. 10346.
Thank you.
And you see that it didn't pass unnoticed, Article 50, because if you look on 10346, just above the bullets in paragraph 5, the principal changes made by the treaty are as follows. So, principal changes made by the treaty, over the page, 10347, fourth bullet down. And of course, just by way of note, that was, and put that bundle away, that Article 50 was a provision that increased the powers of the European Parliament because they had to be involved in the Article 50 process. And so Parliament had to grant specific consent inter alia for that reason. And that explains the content, if you go back to page 119 in Volume 1, that we've just been looking at into the 2008 Act, that explains the content of Section 4. So the 2008 Act adds Lisbon to the list of now renamed EU treaties designated by the ECA. And the effect is that Parliament is acknowledging that the other rights and obligations under other parts of the EU treaties, we've touched on this point before in debate, were now subject to the exercise of the Article 50 withdrawal right. So the idea that they could thereafter be regarded as set in stone or permanent cannot be maintained after that.
The increase in powers of the European Parliament related to a whole range of
It did.
things.
So I said inter alia. It did. My Lord is right. But this was one of them, because you'll remember that European Parliament has some involvement in the Article 50 process. So that's the second of the bits of significance, as it were. We've gone from 5 back to 4. We go forward to Section 6, page 120. And this is significant because for the first time, Parliament passes in Section 6 a series of parliamentary controls over decisions ministers took under various parts and processes of the treaties. So this isn't control over entering into new treaties or ratifying new treaties. This is about the performance by the government of its functions under the treaties, prerogative powers being exercised, therefore. And the list is set out in section 6.1 and applied both to the TEU and the TFEU. And the terms of section 6.1 are restrictive. The Minister of the Crown cannot exercise the prerogative power of the Crown in respect of specific enumerated decisions. But they are enumerated. The controls are nuanced. And they are not merely identified, as it were, the specific things that now need some form of parliamentary authorisation, but the mechanism of control is itself nuanced. You see that the species of control that this section provides for in section 6.2 is parliamentary approval of motions. So you've got within the same Act the various decisions that we say Parliament would be expected to make if it entered into the territory of trying to control the government's prerogative powers in the way that it's all fit. We've got the requirement carried over from the previous legislation for primary legislative authority in some contexts, see section 5, and now we've got a different species of parliamentary control, this time motions and approval of motions in section 6 sub 2.
Is it in fact that different? As I understand it, the 2008 Act extended to a large number of species of decisions because the Lisbon Treaty had created a number of procedures for modifying the operation of the treaty, which would previously have required a new treaty, but under the terms of, in particular, Article 48, but there are also other articles, it could be done by intergovernmental agreement internally. So effectively what Section 6 is doing is simply carrying out the policy of Section 5, but applying it to a wider range of decisions which had a similar effect.
And introducing a different mechanism for parliamentary control. It doesn't have to be primary legislative like Section 5. It can now be by a motion and agreeing to a motion. But my Lord is right.
The reason for that difference is presumably that the treaty having been included in the definition of treaties under the 1972 Act would otherwise have simply automatically carried any changes through into English domestic law. So you didn't need primary legislation. A resolution was enough.
Well, but I'm sure that's right. But whether that's right or not, you've still got Parliament thinking about what mechanisms of control it wants to introduce and deciding that it's going to do it in this nuanced way. What the explanation, the base explanation for that might be, I'm sure my Lord is right about that, the basic structure of it and how it all worked and so on. But the fact of the matter is you've got in this legislation consideration of particular types of decision, which ones should be subjected to any form of control, and you've got decisions about what species of control, what mechanisms of parliamentary control are appropriate, demonstrating, we respectfully submit, the fluidity with which that issue is approached. And
these are all procedures under which the competences of the institutions of the EU could be increased or would be increased.
Or the voting system.
Yes, either that you could have qualified majority voting and so on, simplified revision procedure. They're all procedures which would lead to an expansion of the legislative capacity or activity.
True, but you have my points about the significance of it, despite the truth of that statement. We understand. I mean, the key point is the obvious, but we respectfully submit thoroughly important one, when you're trying to assess parliamentary intention against this backdrop, a series of decisions, sourced, however, based on whatever policy considerations, legislative policy considerations, Parliament's all fit to feed into the way in which this Act is structured. You've got primary legislative approval, you've got a different form of parliamentary approval, you've got specific types of decision being subjected to either or both of those features, and you don't have anything at all in relation to Article 50, which did not pass unnoticed, because it was one of the principal changes introduced by Lisbon. So they're looking at
Parliament's attention and the notes you took us to. Yeah, we have that.
You're looking at the very power which is now to be exercised, and you're looking at a piece of legislation which it represents Parliament's considered response to the forms of control it wants to exercise in relation to the new powers introduced by Lisbon. And Article 50 is not one of them. I mean, pose one question. What species of control would Parliament have decided in 2008 it wished to subject Article 52? Section 5 or Section 6? And if there isn't a good answer to that question, then it perfectly illustrates that Parliament's intention was to leave Article 50 well alone. It can't be said, well, it didn't realise it was there. It specifically identified it in the explanatory notes and said, here it is, it's one of the principal changes that's been introduced.
Thank you.
And just to finish on Section 6, Section 6(1)(a), you will note, which precludes a minister voting in favour of a measure under Article 48(6) of the TEU, the Simplified Revision Procedure, and that procedure allowed the European Council to adopt a decision amending all or part of the provisions of Part 3 of the TFEU. And Part 3 of the TFEU includes the provisions on free movement. No need for a treaty amendment before a new treaty before amendment under this procedure. That plainly would alter the content or existence of the rights given under Section 2(1) of the ECA. But on their case, the respondent's case, you couldn't do that without an Act of Parliament. How does that square with Section 6 and its requirement not for primary legislation before a change is made to free movement rights, but simply a motion of each House? On their case, that would be a constitutionally retrograde and inexplicable step. And again, unless there is a good answer to that, their whole thesis becomes difficult to maintain, we submit. That's 2008. 2011, tab 6 in the same bundle, page 136 in the MS numbering. And again, it's in the same vein. Section 6 of the 2008 Act and Section 12 of the 2002 Act were repealed and replaced in the 2011 Act. That's 14(3), I think. But this piece of legislation represents, again, a clear exercise of parliamentary control and precise parliamentary consideration of the very question, where should the proper division lie in relation to matters to do with EU law, between the prerogative on the one hand and parliamentary control on the other? What are the nature and types of control that are to be imposed? How is it all to work? How is that relationship to work? We know it started in the 72 Act with the twin track, the prerogative continues and so on. Now we've got Parliament saying, well, we see how the world is developing, and now we want to exercise very specifically some controls over the exercise of your powers on the international plane. Forget about transposition. We are now going to control, we saw the process starting in 2008, we are now going to control the exercise of certain types of decision-making on the international plane.
So which section is it?
Well, we've got a few to come to. It's sections 2, 6, 7, 8, 9, 10. But just by way of summary, and I'll take you to some of them in a second, but just by way of summary, the result of this legislation is we submit the most significant and extensive set of legislative controls of the treaty prerogative ever seen. It represents a series of detailed and focused controls by Parliament over the exercise of the prerogative under the EU treaties. And sections 2 to 10 impose a series of different sorts of control, this time from referenda for some types of decision, through primary legislation to motions of approval. And it imposes those controls over a series of different types of action pursuant to the treaties, all of which would ordinarily and otherwise have been carried out, exercising precisely prerogative powers, from agreeing a new treaty to giving particular notifications under particular articles of the treaty. So, by way of example, Section 2 makes provision that a treaty which amends the TEU or the TFEU to confer a new competence on the EU may not be ratified unless the treaty is approved by an Act of Parliament and a referendum.
Or the exemption condition.
Yes, or the extension condition. I'm not going to go through all the detail of it, but the detail is worked out in sections 3 and 4. Right. But that's the first type, as it were. Section 6, certain types of decisions of ministers exercising their treaty functions, as you see, are subjected to control by primary legislation again and referendum, including things like adopting the euro or removing border controls.
Including Article 53, oddly, on page MS 155 in Schedule 1. And we get a sort of recognition of Article 50, but at the bottom there.
Yes.
But curiously, you seem
yes.
to in a referendum decide to extend time.
Yes. Which is quite what the explanation for that is, given that it might
I
be
mean,
thought the bigger beast in the room was leaving in the first place.
But certainly, I suppose you can say, well, there was express recognition
of Article 50. My Lord, I'm sorry, I hadn't picked that up, but you're right. Whatever the explanation, there it is. That's section 6. Section 7 deals with types of decision, again by ministers, exercising their treaty functions, and this time they're subjected to control by primary legislation, but not a referendum. And that includes strengthening the rights of EU citizens, 7.2a, by way of example. Not weakening or removing, no control over that. It's not defined in that way. The prerogative power isn't controlled in that way. Section 8. We're going down, as it were, in terms of level of control, but the same point remains. These are nuanced controls. This is a critical act. Section 8, a Minister of the Crown may not vote in favour of or otherwise support a decision under Article 352 of the TFEU unless one of sections 8.3 to 5 is complied with, and that may be primary legislation or motions in Parliament. Section 9, certain notifications provided for under the Lisbon Treaties. And under Article 3 of Protocol 21 to the TFEU and the TEU on the position of the United Kingdom and Ireland in respect of the area of freedom, security and justice, can't be given without parliamentary approval. And approval here means motion, not legislation. And Section 10 on the same theme. Again, motion is the mechanism C10 sub 5. And so the point of all of that is that Parliament has carefully selected, these are the punchlines, Parliament has carefully selected the areas it wishes to control, and it has selected the ones about which it wishes to have a say. And it has done so both by way of identification of the particular type of decision and by setting a detailed, careful and varied scheme as to the mechanics of parliamentary control that it demands. And the rest, we submit, is prerogative as normal. That's the only proper inference of all of this. So the UK continues to send ministers to council meetings, voting on the vast majority of the council's work, without the 2011 Act applying to the body of work that they do.
And I'm right in thinking that where these sections provided for a referendum, they also provided that the referendum, there should be a majority
In favour.
in favour.
Yes.
Is that right? Yeah.
So they automatically produced the relevant consequence, didn't they?
They did, unlike the 2015 Act, is the point my Lord has in mind. That's true. That's true. Yes, my learned friend is pointing out you're not forced to do it. You can do it as a precondition rather than a requirement if it does. So in other words, if there is a majority, you don't have to do it. It's just a necessary precondition if you want to do it. And the final punchline is the obvious one, that despite the fact that it knew full well that Article 50 was still in play, and despite the fact, my Lord Culmouth pointed out that 50 sub 3 is referred to in one of the schedules, in Schedule 1 on page 155, there is nothing to indicate that it's purporting to restrict or control the Crown's decision-making powers under Article 50.
I suppose it can be said again in relation to this that these are all restrictions designed to prevent a creep in EU competence or an increase, and even the restriction relating to Article 50, paragraph 3, is designed to avoid making it more comfortable or easier for someone to leave the EU, isn't it?
My Lord, yes, but the 2 points it might be thought that flow from that are, firstly, that irrespective, as it were, of the underlying motivation or themes linking these changes, they still represent nuanced parliamentary control in the very area. But the second and more impertinent thought might be that if that is truly the explanation, where's the problem where you're not doing that? Of course, there's a different set of questions around how fundamental or grand that thing might be.
You may at the time, I don't know what the political thinking was at the time, but you may at the time have been happy with what you had, but not wished to extend it.
You may or may not. I mean, all that illustrates, it might be thought, is that there may be a danger in seeking to delve too far below for a common theme that is said to affect the nature of this legislation. What they've undoubtedly done is to look at the scheme of powers that the Crown or the government previously exercised on the international plane in this sphere, and have said we're going to control that, and that, brackets, and not that.
Yep.
And that, we respectfully submit, is the key significance of this Act.
Yes.
Just before moving to the 2015 Act, it may be worth just mentioning a point which the Divisional Court placed some reliance upon, which was that in a case called Thoburn, Lord Justice Lords had described the ECA, and I think it would follow logically that he's referring, or can be taken as referring to the entire scheme of EU legislation, as being constitutional in nature. And the Divisional Court placed some reliance upon that because it was thought to suggest that it would make it less likely, because of that description, that Parliament would have intended that the rights conferred by the ECA could be taken away by prerogative powers. However, in relation to that point, firstly, constitutional status in that sense entails that legislation itself is protected against implied repeal by later legislation appearing to be inconsistent with it. So that was the force of the point. That was the point that was really an issue in Thoburn. And so it's a doctrine which sounds in the principles that are that the courts have decided should govern implied repeal, and those are, of course, common law principles discovered by the courts as a mechanism for dealing with that set of issues. It doesn't tell you anything about Parliament's intention or about the interpretation of a statutory scheme, and it can't, therefore, we respectfully submit, be used to displace the de Keyser approach or what the scheme read properly as a whole tells you about parliamentary intention.
Mr. Eadie, reading your case, I wondered exactly what your position was on constitutional status. I think you've just indicated you accept the common law does now have a doctrine of constitutional status, and I think you accept that the 1972 Act is a statute of constitutional status. But then you say, so what?
So what? I do. I mean, at the moment, we certainly have not taken issue with that description, or indeed the application or the consequences of that description, designation, that Lord Justice Law has put on it in Thoburn. But we do say, careful, it was about implied repeal, and you can't just say, well, there's a constitutional-looking statute, and ergo it has some enhanced status which renders it less likely that the government could withdraw from the treaties that sit alongside. And in any event, if you are to take that forward, so it's a doctrine that sounds in implied repeal is the first point. And if you're taking constitutionality rather more broadly as an indication of the importance of legislation, then you don't just look at the legislation and say, well, that might fit that sort of description. You have to drag in all the other essential foundations of the Constitution that play into the particular area.
But if the common law so far indicates that the doctrine is one where there is a constitutional statute that can't be implied repeal, namely, it can't be repealed by a side wind, I think one of the arguments against you is that for the prerogative now to be emptying the 1972 Act of content is a different sort of side wind.
My Lord, that is one of the arguments put against me, and my essential answer to it is that constitutionality is to be judged in the round, and it includes the prerogative as an essential foundation constitutionally. It includes the 1972 Act being set up at its base on the basis of continued dualist operation, and it includes, if ultimately you're searching for Parliament's intention, which is what this game is all about, these are simply aids to working out what Parliament has intended by the legislative scheme, it includes, we submit, the entirety of the legislative scheme. And so if the 72 Act is to be described as constitutional, that is a description that can't be, as it were, imposed on the 72 Act and then forgotten about when you look at the later legislation dealing with exactly the same sphere or context. And so if you're looking at the scheme and you're saying constitutional, you take into account dualism, you take into account the existence of prerogative, and most importantly perhaps, and this is the theme I'm now on, you take into account the entirety of the legislative scheme. And what that tells you is that when Parliament wants to control the exercise of executive power on the international plane, it says so and it does so, not merely generally in relation to CRAG, with its as it were, general controls over treaty ratification, but the very specific and nuanced scheme that I've just taken you through. So that's my answer. I think yes, but is the answer.
But perhaps in your submissions tomorrow, you might, I don't know, but I'd certainly be interested in knowing how what you've just said about the need for constitutionality to be judged in the round and the dictum you've cited from Lord Bingham's judgment in Robinson about the need for flexibility in applying constitutional principles, how all that may feed into the approach you take to the effect of or relevance of the referendum result to these proceedings.
Yes. My Lord, well, I'm going to turn now to the 2015 Act. And if at the end of that I haven't answered my Lord's question, someone will make a note to nudge me and I'll do it first thing in the morning. The 2015 Act is in the same volume of authorities at tab 7, MS 160.
Thank you.
And we don't need to spend long on the body of the Act itself. It contains all sorts of provisions about all sorts of things, and it makes no express provision about the legal consequences of the referendum. So the significance, if any, in our context of the Referendum Act is not in relation to what it says, but what it doesn't say. My fundamental submission on the 2015 Act is that that absence does not mean that the 2015 Act is legally irrelevant. And that is how it was treated by the Divisional Court. Indeed, we make the submission that it would be little short of bizarre if that were to be the position. Little short of bizarre because the 2015 Act posed and put to a vote of all the people of the United Kingdom the very question which the Divisional Court and the respondents say has to be re-put to Parliament. And that prompts the question, was Parliament really in 2015, in passing that Act, in setting up the referendum, doing no more than simply reserving to itself the right to decide whether to leave or not as it saw fit? Not merely is that highly improbable, but it would run counter, we respectfully submit, to the repeated statements by ministers and by the government, both in the debates leading to the Act in Parliament and in statements outside Parliament. We have in our case, if you could just find that for a moment, in footnote 4, characteristic understatement collected in a footnote, the various statements upon which we rely.
Page reference?
Well, I'm going to give you them.
12337.
12337. Yes, I'm sorry.
Thank you.
12337. And you'll see that I don't think your version of our case probably has MS numbers in it, does it?
Yes.
In the side. Have you got MS numbers for footnote 4? Do you have the MS numbers?
We don't have cross-references.
Don't have cross-references, is that what you mean? But this was clearly stated on many occasions, is that what you...
Yes, exactly so.
Yep. Okay, so we have that, yes.
Well, as long as you've got the cross-references, that's...
What is the nature of this argument? Is it that is it only relevant if there was up until this moment no right to use the royal prerogative, in which case you're arguing, are you, that the Act reintroduces a right to use the royal prerogative? Because if there's already, or is it just confirmatory of a...
It's confirmatory, and it's addressing, and I'm going to tell you the significance in a moment, I may. Yes. It proceeds on the premise that the prerogative is available. But if the concern is, and some of the questions that have been asked by the court indicate that the concern may be, that there is a difference between the ability of government under Section 2 to go all the way back to 72 to alter the corpus of rights from time to time, brackets, but the implicit assumption underlying it all is that something will continue to exist. But this is a whole different beast. The answer is, to come perhaps immediately and directly to my Lord Reid's question, that this serves to allay that constitutional concern. And the reason that I think my Lord Reid reminded me of Lord Bingham in Robinson was because one shouldn't be unduly concerned if one's looking, as it were, for mechanisms of parliamentary control and parliamentary interest. One shouldn't be too concerned about drawing too straight or direct a line. You look to see whether, in the real world, Parliament has effectively sanctioned, to put it loosely rather than legally, that which the government now proposes to do through the exercise of the prerogative. But I make it entirely clear we do not assert that the 2015 Act provides the source, a statutory source of power. The significance of it is in what it doesn't say.
But if you're wrong, standing at 1972, prerogative can't have been exercised, as you argue today, in 1972, how do you say that's changed? Do you say that's changed as a result of subsequent legislation?
Well, we don't say that. We say that the legislative scheme has to be looked at as a piece.
Well, I know you do, but
this is a current issue.
Well, I know you do, but it's the logic of your argument by saying we looked at as a piece is that we could conclude that if we were judging this in 1973, we would be against you, but by judging it in 2016, we can be in your favour.
No, I'm not sure that is the logic of my argument. argument. I'm not sure I'm asserting that, as it were, the later legislation provides a statutory authority or basis for the giving of notice.
Why are we looking at it then?
Because, my Lord, all sorts of concerns have been raised inter alia around the scale of the change and whether or not this is relevant constitutionally, that Parliament has passed this legislation and has set it up.
Well, it's relevant only to this extent, isn't it? That if it is submitted, that in the 1972 Act, nobody contemplated withdrawal. By the time the Act has been amended in 2008, that argument seems no longer available. But it doesn't seem to have any other significance than that.
Well, can I develop the core points we make on it?
Yeah.
And give you them, just so I don't go off-piste and give the wrong answer on this.
Okay, we'll do that, and then we may come back to our questions. That's fair.
Can I just ask one question arising out of the material that was available?
Yes.
In paragraph 107 of the Divisional Court's judgment, they say that they refer to a document which they say made it clear to Parliament that it was only to be an advisory referendum. Is that correct? And if so, where is the document?
It's in Bundle 18, tab 202, MS 6279.
621.
6279.
Thank you.
I'm slightly of my course because I was going to give you another.
You're going to come back to this?
Well, no. Let's deal with it now because we're there. But
I want to come back to it.
If you still have, just by way of, let's have them both open at the same time. If you still have our case footnote 4.
Yes, we do.
I was going to add in, if I may.
Yes, of course.
One further reference to footnote 4.
Yes, what is that?
Which is Authorities 39, tab 509, Supplemental MS 981, a statement by the Foreign Secretary on second reading of the bill, effectively saying this is going to be decisive, it's a matter for the people to decide and not anyone else. And so...
What does this go to? Construction of the...
Well, you'll have seen from the Lawyers for Britain written intervention that they do say it goes to interpretation of the Act. We don't, I think, need to go that far, or don't go that far, but we do respectfully submit that it is relevant, that was the basis on which Parliament was proceeding in passing this Act. And we say that's confirmatory of our position, which is that they left in place the only way in which effect could be given to it, which was to exercise the prerogative power to withdraw and to give the Article 50 notice. That's the significance, but no more than that. And you've seen there's a pretty desultory debate as well about whether or not this Act is properly to be described as advisory, which is the next lead-in point, as it were, to the briefing paper that we have just taken you to. But again, we respectfully submit that there's little that can sensibly be attached to that characterisation, because it could be advisory, either, as the Divisional Court concluded in 106, for lawmakers in Parliament, as they put it, or it could be advisory for government. So it's entirely neutral to call it advisory. Then they say, well, the briefing paper involves, in effect, the government assuring Parliament, brackets, contrary to all the express statements I've just shown you in footnote 4, this is a briefing paper in which the government is the implication, has assured Parliament that it's simply going to be advisory in that sense. The Parliament, the implication being, is going to have another go, whatever the outcome.
Mr. Reedy, before we leave footnote 4,
yes,
had it been your intention to give us the cross-references, which we don't have?
If the cross-reference is within the footnote, that's what my lady's referring to. And
it refers to the Conservative Manifesto, it
yes.
refers to Hansard, and it refers to the leaflet that we all got.
Yes, my lady, can I give you those?
Please.
If you haven't got them. So the first one, the Conservative Manifesto, is Authorities Bundle 16, tab 178.
We have got them. You've got them further up the page.
In this, not in the core volume, but in this, in your...
Oh, I see, in the written one.
Well, I think the best thing to do is for you let us have them in a document tomorrow rather than going through all this rather than taking up court time.
Yeah. Can I ask on a different point? In your references to the whole scheme, looking at the whole legislative scheme, could you give us, if we don't already have it in the papers, an authority on the extent to which these statutes can be regarded as in pari materia, in other words, dealing with the same subject matter, the whole group that you've referred to from 72 up to 2015, or any of them, and the extent to which we can construe an earlier statute by reference to a later in the context of this case. I think it would just be helpful to get the principles.
Exactly. And I will come to that. Just before I make my full principal submissions on the statutory scheme, I've got a little section that says, is later legislation after the 1972 Act relevant?
Good.
So you're going to get it, but I promise to write it down.
Yes.
But it's of some significance because the divisional court proceeded on the fundamental premise that it wasn't. So I'm going to have to address that. But so advisory I've dealt with could be advisory for government as well as lawmakers, not undermined by the briefing paper. We've got to the briefing paper. Short points in relation to the briefing paper. First one is that this is a House of Commons library briefing paper. Some concern, I think, may have been expressed by House of Commons authorities as to the appropriateness of referring to it, but it's referred to in the Divisional Court's judgment, so that horse may have bolted. But Part J, Article 9 of the Bill of Rights, it is a House of Commons library briefing paper, not written by government, but by a member of House of Commons staff. It tells one nothing, therefore, about the intention of government. It is not an assurance to Parliament by government. It is not anything that would bear on parliamentary intention. It is not a legitimate aid to interpretation. And if it's being suggested that this is some form of government statement to the House, then it would need to be set alongside the absolutely clear statements that are collected in footnote 4 of our case. But we respectfully submitted a more fundamental view. It is unhelpful in terms of assessing whether or not the 2015 Act is to be treated as advisory in the sense that the Divisional Court used that term in. So that's what I say about that document. I hope that answers my Lord Clerk's question on that. Two core points on the 2015 Act, if I may. The first is, and this is its true legal significance, we respectfully submit, is that it proceeds on precisely the same footing as the other parts of the scheme of control over the conduct of international relations by government. It makes no provision seeking to control the prerogative powers that the government exercises. It imposes no requirement, as other acts had done in the same territory as we've seen, for primary legislative authority before any step is taken in the exercise of those powers, nor indeed for any of the other nuanced forms or mechanisms for parliamentary involvement, and that no doubt is because it is itself primary legislation. Specifically, there is nothing to constrain the government giving Article 50 notice. Its significance in legal terms is precisely that it does not do so, as it could perfectly well have done, see the raft of earlier legislation. And the silence we submit is compelling and consistent with the rest of the legislative scheme. And that point is powerfully reinforced by two other facts. Firstly, in the event of a decision to leave, if that was the outcome of the referendum that Parliament set up, the process of withdrawal had to commence in the prescribed way. Article 50 notice was the only, and under the Lisbon Treaty, the mandated first step. And as we already know from the legislative scheme that we've gone through, from 2008 and 2011 in particular, Article 50 has already been considered by Parliament and left in the hands of the government. So that's the first reinforcement. The second is, moreover, the 2015 Act represents specific contemplation by Parliament of precisely the sort of impact on rights and obligations that would flow from withdrawal. Do we leave the club, is the question that the referendum posed. And if we do, the processes of the club necessarily go. The effect on rights necessarily occurs, and Parliament was plainly entirely alive to that fact. It couldn't possibly be improper to use the prerogative to give effect to the results of the democratic process that Parliament had chosen to set up. The counterposition, it might be thought, is worth at least considering. It involves contending that Parliament had left Article 50 and the giving of an Article 50 notice within the prerogative sphere in the earlier legislation, and the 2015 Act, in effect and implicitly, reverses that position and now requires that the giving of such notice should be subjected to primary legislative authority. So they've already considered Article 50 in 2008 and in 2011, and the thesis that is now advanced is that in 2015...
Now, I think the point, the way it would be put against you, I suspect, is that under the 1972 Act it wasn't left with the prerogative, and no subsequent act was inconsistent with that, because that was the position in 1972, and that's what it remained. That's the argument.
My Lord, that may well be the submission. There isn't a point about the 2015 Act. If they're right at that base level, then so be it.
Yes. But
Yeah.
I think
that was the point you were putting to me earlier.
Yeah, but I think that's what's put against you. I don't think it's put that it survived any differently.
But we respectfully submit that there is but there is a jump, we respectfully submit, between 2011 and 2008.
I can understand what you say.
And 2015.
Yeah,
that contrast is stark. The second core points on the 2015 Act is that it was passed with Parliament acknowledging, at the very least, the political realities associated with the scale of the decision to stay or leave. And we respectfully submit that the proper implication from that Act is that in doing so, Parliament was acknowledging plainly, consistently with the statements that happened to have been made, that the vote should decide that question, and that all concerned, including Parliament, would respect the outcome. And on that basis, it has obvious constitutional significance. In the Schindler case, which, as you will recall, preceded this litigation, the Schindler case is, I'm going to turn it up now, but it's in Core Authorities, Volume 3, Tab 18, MS 627, and Lord Dyson, at paragraph 13, describes the matter thus. He says, the referendum, brackets, if it supports withdrawal, is an integral part of the process of deciding to withdraw from the EU. And we respectfully submit that that is an entirely correct characterisation of what the 2015 Act was doing. It ascribes proper constitutional significance to the fact of the referendum and to the fact that Parliament has itself decided to put that decision to the people in the vote. I add in parentheses that some of the other parties, the Pigney and expat respondents, suggest that Lord Dyson was also indicating that he expected that Parliament would have a role in that process. We respectfully submit that when you actually consider the issues that were truly being debated in Schindler, that point is not a good one. But the significance, and you can see that from just looking at paragraphs 13 and 19 in their context, but the true significance of it is in the correct description, as I just indicated. The referendum, he said, if it supports withdrawal, is an integral part of the process of deciding to withdraw from the EU. And, of course, the 2015 Act frames the question we submit now to be asked. And it does so in circumstances in which Parliament has evidently confronted the consequences of the binary question that it put to the people, including, at a basic level, the consequences that some rights and obligations flowing from membership of the club would not be available, and specifically contemplating, in the leave part of the binary question, the very effect on rights, which it is now said is constitutional anathema. And so we respectfully submit that it is not correct to treat that as legally irrelevant. The legal effects and the legal significance may be more or less subtle, but they are direct in the sense of it leaving the prerogative power, the Article 50 power in place. And if one chooses to view the matter more broadly constitutionally, the effect is precisely as Lord Bingham described it. Is the later legislation relevant? Lord Mant's question. We respectfully submit that it's a current question. Legislative impact on prerogative powers can and does change as the legislative scheme alters. And Article 50, of course, doesn't arrive until 2008. So you could hardly freeze that issue in 1972. So you don't grapple, we submit, with 1972 in isolation because of the nature of the question that you're asking, which is the current state of prerogative powers. You take the legislative scheme as it exists, in its entirety, as of the date on which you're asking that question. In other words, today. In any event, we submit that there is good authority, which at the very least implies at a high level of judicial decision-making, that constitutional issues of the kind that confront you today need to be determined in the light of present constitutional circumstances. That is the true significance, we submit, of the ECA and that legislative scheme governing EU matters, EU treaty-making. That's the true significance of describing that legislative scheme as constitutional. And we do respectfully submit that in that respect, the Robinson case to which reference has already been made is of real interest. We've given you the quote from Lord Bingham in our annex to our case at paragraph 3, but Robinson itself, which I'm not going to take you to, but which I recommend to the court, if I may, Core Authorities, Volume 4, Tab 81, MS 3272, Lord Bingham. Can I therefore make 4 principal summary submissions?
Which page is Lord Bingham's observation on? Sorry. Let us know later, it's all right.
It's paragraph 12 of Robinson.
Yes, I think it's paragraph 12.
Check the way back now.
That's what you quote in your annex.
That's the one. It's paragraph 12 of quoting, yeah.
Okay, that's fine, we'll find it, thank you.
Yes, in any event, I think this is the point my Lord Mance asked expressly, the impari materia one. I can't remember whether we've got cases in our case, but to support that. But if we do, I think it's our case at paragraph 76. We respectfully submit in any event on ordinary principles of interpretation, it's legitimate to rely on later parts of a scheme when considering the 1972 Act. Firstly, because the 2008 Act amends the 1972 Act. That's our case at paragraph 75. And secondly, because we are in impari materia territory. That's our case at paragraph 76. The citations there set out. 4 principal summary submissions then on the statutory scheme, trying to draw the points together, if I may. Submission 1 is that the shape of the schemes of control over the exercise of prerogative powers represent precisely the exercise of parliamentary sovereignty. Parliament has considered what the nature of those controls should be. Parliament knows what prerogative powers in the conduct of international relations exist in relation to the making of treaties, in relation to the negotiation of treaties, and in relation to withdrawing from treaties. Those are all proper parts of the generally expressed, the generally characterised prerogative power. And that is, we submit, the legislative premise or base position on which the scheme of legislation exists and the prism through which it is to be viewed. So the specific controls that Parliament has seen fit to enact in the scheme I've taken you through represent their considered view as to the extent of its encroachment onto that base position. onto those base powers. And the base position is otherwise left in place. That's why it's as significant to examine what Parliament has not done as to examine what it has done. That's why I started my submissions in describing the prerogative by indicating that its source was not legislative, but that it had its own freestanding common law source. And it's for Parliament to make those decisions, we submit, about the extent of encroachment, to craft the scheme of control, to make the legislative policy decisions as to when and in what form it wants to exercise that control. Those aren't decisions which we respectfully submit the courts can or should make under our Constitution. And so applying the scheme of control that Parliament has chosen is, we submit, an acceptance and not an abnegation of parliamentary sovereignty. That's the first submission. The second submission is that Parliament, it is clear, has legislated expressly, both generally in relation to the EU, to establish the nuanced system of controls you've seen. And it has conspicuously refrained from making any provision to control the withdrawal from treaties or the steps commencing a process leading to withdrawal. It has not done so in CRAG, which is all about ratification. It has not done so when specifically considering which types of decision in the EU context, our very context, should be the subject of what forms of control.
I suppose if one's being really technical about it, it has legislated to control the exercise of the prerogative in relation to the withdrawal of other countries from the EU. That's Lord Carmouth's point about the inclusion of Article 50, sub-Article 3 in Schedule 1.
My lady, yes, you're right.
If one's being really technical
yes,
about
no,
it.
you're right. Can I add, subject to my lady's point, to the point I've just made then?
Forgive me, I didn't mean to put you off the stride.
Not
my intention.
That caveat, the subject to, was the next point I was going to, not quite there, but it was going to be there was no express provision that Article 50 notice or withdrawal is subjected to legislative conditions and must thereafter be exercised accordingly. Of course, there are the controls which my lady has just reminded me about, but in relation to the exercise of our powers, there is no control in that way. The clear position, indeed, is directly to the opposite effect. The controls and the limits of the controls have been decided upon and made the subject, unsurprisingly, of express provision. And the rest is prerogative. And that was the basis on which the 72 Act proceeded. That was the basis on which each of the pieces of legislation thereafter proceeded. And that was the basis on which the 2015 Act proceeded, albeit with its additional constitutional significance of the kind that I've indicated. And there is therefore, we submit, no necessary implication. No necessary implication, because in this sphere, this is the force of the reasoning of Lord Justice Lloyd in the Rees-Mogg case, Parliament, when it wants to exercise control, has done so very deliberately and very expressly. And so we are not in the sort of territory that you had in all of those earlier Decazar-type cases. We're not dealing with a situation in which Parliament has said, this is the activity that you can do, and if you're going to do it, these are the controls, these are the regulations, these are the preconditions. You have to jump over hurdle A, B, and C, and then you can exercise the power. That's what has created the necessary implication, or something virtually analogous to that, in the past. And we're simply not in that territory. We're nowhere near it. Because what that requires, as we saw from Decazar, is a very precise identification of the nature of the act in question. What is the act in question here? It's the giving of Article 50 notice. And there's been no control over that at all. There is no direct regulation. There is no regulation at all of that activity. And so there is no necessary implication, A, for the reason given directly transposable into our context by Lord Justice Lloyd and Rees-Mogg, but be in any event were one to apply properly the reasoning and principles laid down by the House of Lords in Decatur and subsequent cases, for the reason I've just identified. And it is self-evident, we submit, that withdrawal or revocation of the treaties has the potential to affect EU-related rights and obligations in a very serious way. And Parliament knew that, and yet left that power untouched, that prerogative power untouched. No one can pretend that they weren't fully aware of what would happen if Article 50 notice was given. It was one of the principal changes made by the Lisbon Treaty noted in the explanatory notes. If its intention truly had been to subject leaving or withdrawing to a requirement for primary legislation, not merely could it have said so, but we submit it undoubtedly would have said so. Undoubtedly, because it is evident that in those pieces of legislation I took you to, particularly the 2008 Act, it was specifically considering both, and they are distinct aspects, the mechanisms of transposition into domestic law and conduit, the stuff of the 72 Act, Part 1 and Section 2 in particular, and the stuff of the later legislation in particular, the controls it wished to impose on the exercise of prerogative powers by government on the international plane.
And you take from the authorities that you cited this morning that the current state of a prerogative in relation to this matter depends on the current state of the statute book, and what the answer might have been in 1972 isn't actually the issue.
Yes, and you don't freeze it there. You don't, as it were, get to a place where you say, well, the Act must have had that meaning then, so it didn't. You're not in that territory at all. You're in the territory of asking a current, fundamentally important constitutional question. And this court, in particular, I hesitate to say, but this court in particular has shown itself to be well aware of the concerns about the law reaching conclusions which the ordinary man and woman on the street simply wouldn't understand. If you said to the ordinary man or woman on the street, do you regard the fact that a referendum has occurred to be remotely relevant to the question whether or not the government can give Article 50 notice? The answer would be, of course it is.
Well, if you put it as remotely relevant,
well,
don't say as a matter of law.
Relevant as a matter of law.
Well, as a matter of law, they'd probably say, well, I'll ask a lawyer. I mean,
well, certainly. But the divisional court's conclusion is that you just exclude that from the court's consideration. See that? They say it's legally irrelevant. And we respect
relevance as a matter of law is for what it doesn't say, what it assumes.
What it assumes. That's how we put it.
Your position really is that the source of the power was and remains the prerogative.
The source of the power was and remains the prerogative. That was my first fundamental point about it. And my second one was, as it were, the rather looser constitutional point, designed to scotch concerns about scale, if I can put it that way.
Yes.
Yeah. And that may be a convenient moment to break. I mean, I think we're on track. So.
Thank you very much for letting us know that. 10:15 tomorrow, or as soon thereafter as we can come in. Thank you very much indeed. Court's now adjourned.